houses of assembly, National Assembly and governorship elections, the Constitution gave jurisdiction to entertain disputes from presidential elections only to the Court of Appeal. Thereafter, the Constitution was intentional and deliberate in setting the 180 days limit only for elections tribunals and not for the Court of Appeal. End of quote. It is shocking to have the above argument in print. It could have passed for a friendly joke, but not for a serious matter like this in the apex court. It is even an unnecessary joke over a constitutional provision. After election petitions had suffered under the previous provisions, which allowed election petitions to be heard even until the respondent has completed his tenure, and the National Assembly dealt with the mischief by limiting the time which election petitions shall be determined, it is unfair to suggest that we go back to those dark days. My lords, there is nothing in Section 285(6) of the Constitution to suggest that the Court of Appeal can hear presidential election petition without time limitation. The lower court is bound by the provision of Section 285(6) of the said Constitution when sitting to hear election petition, just as other election tribunals, as was rightly submitted by the learned senior counsel for the third respondent, Chief Akin Olujimi S.A., for which I wholly agree. The appellants knew they had to prove the allegation of non-qualification raised at paragraph 16D and 146 of their petition against the second respondent within the 180 days adjudication window provided in Section 182 sub 8 of the Electoral Act 2022 for determination of petition by the lower court, which expired since 17 September 2023. The 180 days having expired, the lower court therefore no longer had jurisdiction to allow the deposition sought to be introduced into the trial of this petition. This is the law which at this stage is elementary. Consequently, since the lower court no longer has jurisdiction to entertain any such application, it follows ipso jure that this Supreme Court, also has no jurisdiction to allow the deposition to be used in this appeal. It is settled law that where the time for doing a thing is limited by the Constitution or statute, the court cannot extend the time. That was the decision of this court in Brigadier General Mohammed Buba Mawar and Admiral Morotala Nyako, where Onogan JC as it then was held as follows. Quote, it is settled law that the time fixed by the Constitution for the doing of anything cannot be extended. It is immutable. It is fixed like the Rock of Gibraltar. It cannot be extended, elongated, expanded, or stretched beyond what it states. See also Abubakar and Nassam, all citations supplied. It has to be noted, as I stated earlier in this ruling, and for which there are several judicial decisions in this country, that the 180 days imposed on election tribunals and courts hearing election petitions is immutable and cannot be extended. The applicants have not even applied for extension of time to bring in the said depositions or extension of time to amend their petitions. Let me say it clearly that 21 days provided for the filing of petitions having long expired, even if the appellants had applied for extension of time to amend their petition in order to bring in the depositions, it would not have been granted based on the provisions of the Constitution and the Electoral Act. This principle was again restated by yet again Onogan JSA as it was in NNPP and Goni. Citations supplied when he said, despite the decision of this court since October 2011 on the time fixed in the Constitution, some of the justices of the lower court still appear not to have gotten the message. From where will the election tribunal get the jurisdiction to entertain the retrial after expiration of the 180 days assigned by the Constitution? The answer is obviously in the negative. It should be constantly kept in mind that prior to the provisions of Section 285(6) of the 1999 Constitution as amended, there was no time limit for the hearing and determination of election petition by the election tribunals or the appeals arising therefrom. That situation resulted in undue delay in the hearing and determination of an election petition by the election tribunals or appeals arising therefrom. The amendment to the original Section 285 of the 1999 Constitution by allotting time within which to hear and determine election petition and appeals arising therefrom is designed to ensure expeditious hearing and conclusion of election matters. If the decision of the lower court is allowed to stand, as urged by the respondents, it will reintroduce the earlier mischief which the amendment sought to correct. End of quote. See also Uba and Suswan. Citation supplied. The above statement by this court is very explicit, clear, and simple. As it is, the provision of the Constitution has spoken. There cannot be an addendum or another reopening of the case at the lower court, its jurisdiction having lapsed. My noble lords, I've taken time to state the law on the issue to show the futility of this motion. It cannot be granted. The jurisdiction of this court is donated by the Constitution and the Electoral Act regarding election petition appeals. We do not have the virus to admit this position, and we cannot invoke Section 22 of the Supreme Court Act, since the lower court has since lost its jurisdiction. More so, there is no paragraph of the petition to accommodate a case of forgery. Again, the appellants have distilled 7 issues for the determination of this appeal, and none relates to certificate forgery. One wonders what the appellants intended to do with the deposition, since appeals are heard on the issues distilled for determination by the parties in this court. In Saliba and Jackson, 2002, for Nigeria Will Report, citations others supplied, this court stated clearly that all appeals are decided upon the issues formulated for determination. What this means is that any matter not covered by any issue for determination is of no moment. Should the deposition be admitted, it will float in the appeal, as this court cannot exercise original jurisdiction even if we are to start a new case for the appellants. See Sanusi and Ayula, Chitex Industries, and Oceanic Bank, citations supplied. Finally, my noble lords, on this application, I wish to state that fresh evidence is not received as a matter of course. There are conditions which must coexist before the court can grant this type of application, as can be garnered from the decided authorities of this court, which include, but not limited to Onwu, Buariri and others, and Igbo, Oyosi and others, Supra. Adegbite and a motion are cases cited by the Senior Counsel by the second respondent. Simply put, the conditions for the grant of this type of application are that: 1, the fresh evidence could not have been obtained with reasonable diligence at the trial. 2, such evidence, if admitted, would have important effect on the subject of the appeal. 3, such evidence ex facie is apparently capable of being believed. 4, such evidence would have influenced the judgment of the lower court in favor of the appellants had it been available. And 5, and if such evidence is admitted, further evidences from the opposing party would not be needed. Taking the first condition, for example, the appellants failed to convince this court on why it waited until after the court below delivered judgment in the petition and lost the 180 days donated to it by the Constitution before bringing the said depositions sought to be admitted in this court. It has to be noted that appeals are a continuation of hearing of the matter in the lower court. As was pointed out by the learned senior counsel for the first respondent, A.B. Mahmoud Esse, the presidential election was conducted on the 25th of February 2023, and the first respondent declared the second respondent as winner of the election on 1st March 2023. Thereafter, the appellants filed their petition at the registry of the court below on 21st March 2023. If I may ask, what attempts did the appellants make between the publication of the second respondent's Form EC9 and accompanying documents in June 2022, a year more than a year ago, and the date of filing the petition on 21st of March 2023 to obtain the documents from Chicago State University, which could have been used at the trial court? Again, what attempts did the appellants make to obtain these documents between the date of filing the petition and the conclusion of trial? To say the least, the above questions are critical in the quest of this court's efforts to decide whether the new evidence sought to be adduced could have been obtained by the appellants with reasonable diligence for use at the trial. And with due respect to the appellants and their counsel, I think they were a bit tardy and were not reasonably diligent in their attempts at obtaining the documents which they seek to have this court seek in this appeal. In Adeleke Aserifa Asupra, this court held that where the evidence is available and could with reasonable care and diligence be made available to the applicant at the time of the trial, as in this case, the court should refuse to exercise its discretion to receive such evidence. From all I have stated above, it is crystal clear that the additional evidence by way of the deposition of oath does not fit into the issues submitted for the determination of this appeal. The application, my lord, of the appellant applicants in the circumstance is thereby refused and accordingly dismissed. I now go to the main appeal. I want to say that the motions filed by the respondents to challenge some issues, grounds of appeal, we have decided to ignore them, strike them out, and hear the appeal on the merits. The latest senior counsel for the appellants distilled 7 issues for determination. All of them, except the last one, the third respondent submitted 6 issues. So we have stated all there are 7 issues in the judgment. You will see them when you get copies. There is no doubt that all the issues submitted by all the parties are similar, and any could be adopted for guidance. I propose, however, to determine this appeal based on the issues as formulated by the appellants. After all, it is their own appeal. Issue 1. The thrust of issue 1 is whether the lower court was right in refusing to hold that the failure of the first respondent to electronically transmit results from polling units nationwide for the collation of results introduced by the Electoral Act 2022 and specified in the regulations and guidelines for the conduct of elections 2022 and manual for election officials 2023 does not amount to non-compliance, which substantially affected the outcome of the election. Chief Krisuche Esse, learned senior counsel for the appellants, submitted in the main that by virtue of Section 64, Sub 4 of the Electoral Act 2022, the collation officers and returning officers of the first respondent, including the national chairman of the first respondent, were under a statutory obligation towards mandatory verifications and confirmations at all stages required before the announcement of the results of the election. Learned Silk further contended that at the trial of the appellant's subpoenaed witnesses, several INEC presiding officers, including PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25, who handled the BVAS machines at the polling units on the election day, who confirmed the non-transmission of results of the presidential election electronically from the BVAS machines, whereas the results for the National Assembly election held simultaneously were electronically transmitted without difficulty. That the appellant's witnesses gave evidence that the bypass of the use of the prescribed verification technology was nationwide, affecting the entire polling units and collation of results all over Nigeria, and substantially affected the outcome of the election. That the sole witness of the first respondent, Lawrence Biode, admitted under cross-examination that the deployment of the technology of BVAS and IREV was to guarantee the transparency of the electoral process and the integrity of the results, but claimed that there was a technical glitch that made the system fail to work on the election day, which technical glitch was not explained by the first respondent. The appellant contended that the failure to transmit the results electronically led to manipulation of the results in favor of the second respondent. Learned Silk then urged this court to depart from its previous decisions pursuant to Order 6 Rule 54 of the Supreme Court rules on the manner of proof of non-compliance with the provisions of the Electoral Act in the light of the novel provision in Section 132 of the Act and paragraph 46 sub 4 of the first schedule to the Electoral Act. The learned SN submitted that the assurances given to the public by the first respondent as a public institution that results will be electronically transmitted was dashed. It is his contention that the election ought to be nullified by reason of the gross misrepresentation by the first respondent based on the doctrine of legitimate expectation as applied by this court in Stitch and AG Federation. Citation supplied. The learned Silk concluded on this issue that given the introduction of technology into the collation process by the new Electoral Act 2022, the judicial approach and the attitude must of necessity be different from the analog past. He then invites this court to depart from its decisions on mode of proof of non-compliance with the Electoral Act in election petitions, as was the case in Nyesom Wike and Peterside, Okereke and Umahi, Shinkafi and Yari, amongst others. He urged the court to resolve this issue in favor of the appellants. In response, the learned senior counsel for the first respondent, Ebi Mahmoud Hussein, urged this court to decline the invitation to override its previous decisions on the manner of proof of non-compliance because such invitation is not usually taken lightly by this court. He contended that the conditions for such application does not exist in this appeal, relying on VP Industries Limited and Cocoa Industries Limited, citation supplied. He contended that the appellant has not contended that the previous decisions sought to be departed from were given per incuriam or erroneous in law. On the argument that first respondent failed to electronically transmit results, he submitted that the only reference to electronic transmission of polling unit results appears in paragraph 38(1) of the guidelines published by INEC for the conduct of the election, wherein it provides that presiding officers shall electronically transmit or transfer results of the polling units directly to the collation system prescribed by the first respondent. That the use of the word "or" in the said paragraph 38(1) of the guidelines gives the presiding officer the discretion or option to either transmit electronically or transfer the result to the collation system prescribed by the first respondent. Learned Senior Counsel submitted that the main complaint of the appellants relates to the alleged failure to transmit the election result to the IREP portal for members of the public to view, and that this amounts to non-compliance. He submitted that the IREP portal is only a public viewing portal and not a collation portal, relying on Oyetola and INEC citation supplied. He urged the court to hold that the failure did not substantially affect the result of the election, which was properly collated and results announced. In his argument, Chief Olanikpekun, for the second respondent, submitted that by all extant relevant laws, INEC has the prerogative of determining the mode and manner for the transmission of election results, and that the lower court was perfectly right, and in order when it so held. He faulted the appellant's claim and basis of allegation of non-compliance with respect to the presidential election in focus on their claim that the results of the election results were not electronically transmitted to the IREP in real time, not that it was not transmitted at all, and that the first respondent did not ensure that the results were collated on the IREP. He also faulted the appellant's insistence that the results ought to have been collated electronically on the IREP, and that omitting to do this automatically nullified the result of the election. Referring to the case of Labour Party and INEC, suit number FHC ABS-CS 145/2022, delivered on 23/1/2023 by Wite J of the Federal High Court, which decided that there is nothing in a combined reading of sections 47(2), 52, 65, and 62(1) and 2 of the Electoral Act 2022, which suggests that INEC is mandated to only use an electronic means in collating or transferring of elections result. Rather, that INEC is at liberty to prescribe the manner in which election results will be transmitted. That by section 287(3) of the 1999 Constitution, all authorities and persons are bound to enforce the terms of the judgment until set aside by an appellate court. He submitted that all through the gamut of the Electoral Act, the appellants were unable to refer to the lower court a single provision which prescribed electronic collation of result or even electronic transmission of result, and that was why the court below held that the petitioners were unable to prove that the Electoral Act or guidelines made it mandatory for electronic collation system. He submitted further that the appellants failed to show that the results collated was different from the one they perceived belonged to them. Learned Soul submitted finally that the Electoral Act 2022, the INEC regulations and manual, points irresistibly to a manual collation of results, contrary to electronic collation touted by the appellants. The reason being that by paragraph 93 of the regulations, the only circumstance where electronic copy of results becomes relevant is where there is no hard copy of the result. Then the electronic copy can be resorted to during collation. Learned Counsel Olanikpekun urged this court to resolve this issue against the appellants. In his submission, Chief Olujimi SN, for the third respondent, submitted that the appellants seem to have admitted their failure to prove allegation of non-compliance when they pleaded with this court to depart from the earliest established legal position that non-compliance be proved on polling unit basis. He submitted that there is nothing compelling presented by the appellants to warrant a departure from the established legal order, relying on Wike and Peter's side, Belgore and Ahmed citations supplied. He urged this court to decline the invitation. According to Learned Soul, any arguments for relaxing the established standard of proof of allegation of non-compliance must not be driven by sentiments and cavalier presentation of a case seeking to overturn the will of millions of the electorate in a presidential election. He contended that the appellants merely half-heartedly offered 27 witnesses many of whom were incompetent witnesses, while purporting to prove allegations of non-compliance covering 176,000 polling units spread across the 36 states that make up the Federation of Nigeria. He argued that based on the inadequate evidence, the allegation of non-compliance must fail, relying on Buhari and Obasanjo, Atiku Abubakar, and INEC, all citations supplied. He urged the court to resolve this issue against the appellants. In their reply brief, the learned senior counsel for the appellants faulted the response of the respondents in relation to their call for this court to depart from its previous decision touching issue of non-compliance. According to him, his argument is based on the introduction of Section 65 and 6 and 187 of the Electoral Act 2022 and paragraph 46.4 of the first schedule to the Electoral Act, which provisions were not in the 2010 Electoral Act, that these new provisions deal with the new manner of transmission of results as contained in paragraph 38(1) and 2 of the Regulations and Guidelines for Conduct of Elections 2022 and the legislative intervention to reduce calling of numerous witnesses. This is what the court has to say. By Section 135, sub 1 of the Electoral Act 2022, an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this Act if it appears to the election tribunal or court that the election was conducted substantially in compliance with the principles of the Act and that the non-compliance did not affect substantially the result of the election. From the provisions of the Act stated above, it is crystal clear that a petitioner seeking to nullify an election on the ground of non-compliance must not only lead evidence to prove the non-compliance, but must also show to the court how the non-compliance substantially affected the outcome of the election. A petitioner in this situation must therefore adopt a kind of double-barrel approach. You don't fire one barrel and leave the other intact. Both must be fired together at the same time. From the evidence as can be garnered from the record, the judgment of the court below and the arguments of both parties in this appeal, one thing is very clear, and that is the appellants abandoned the duty imposed on them to lead credible evidence to prove non-compliance, but relied solely on the failure of the first respondent to transmit results real-time to the IREF portal. According to the appellants, this was enough to nullify the election of the second respondent. What exactly is the IREF portal? The court below held that the IREF portal is not a collation system. This court in Oyetola and INEC made it clear that there is a difference between a collation system and the IREF portal, though both are part of the election process. Whereas the election system is made up of the centers where results are collated at various stages of the election, the INEC result viewing portal is to give the public the opportunity to view the polling unit results on the election day. What this means is that where the IREF portal fails, it does not stop the collation of results, which up to the last election was manually done. The failure or malfunctioning of the IREF deprives the public and even election administrators and monitors the opportunity of viewing the portal and comparing the result collated with the ones transmitted into the IREF. Truth must be told, the non-functioning of the IREF may also reduce confidence of the voting public in the electoral process. My lords, The Electoral Act empowers the first respondent to determine the electronic device to be used during election and their purpose. The lower court held that the IREP is not a collation system, and I agree. I refer to paragraph 93 of the first respondent's guidelines and regulations for election, which provides that, and I quote, where the INEC hard copy of collated results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the IREP portal to continue collation. When none of this exists, the collation officer shall ask for duplicate hard copies issued by the Commission to the following in the order below. 1. The Nigeria Police Force, and 2. Agents of political parties. End of quote. Paragraph 93 of the first respondent's guidelines and regulations reproduced above shows clearly that recourse to the electronically transmitted result for the purpose of collation will only arise where the hard copy of the result sheet does not exist. Given when the electronically transmitted result or the result on the IREP portal does not exist, the Commission will ask the copies handed over to the Nigeria Police or agents of political parties. The elaborate arrangement made by the first respondent for collation of results is to make sure that at every point of collation, there is a result either from the hard copy with INEC or the electronically transmitted copy or the IREP portal copy or a hard copy given to the Nigeria Police, and finally, or a copy given to political parties. I think I can confidently say, and in agreement with the respondents, that the unavailability of the election results on the IREP portal, for whatever reason, cannot be a ground upon which an election could be nullified, particularly as it is not the case of the appellants that the hard copies of the result sheets did not exist at any level of collation. My Lord, having failed to prove its petition by conventional method known to this court, the appellants urge this court to depart from several decisions of this court on ways of proving non-compliance. They have not shown that those judgments were reached per incuriam or that there was any miscarriage of justice. See some cases cited. Section 137 of the Electoral Act relied upon by the appellants for their failure to prove non-compliance in the manner we are used to provide, and I quote, "It shall not be necessary for a party who alleges non-compliance with the conduct of elections to call oral evidence if originals or certified true copies manifestly disclose the non-compliance." End of quote. The above provision has not absolved a petitioner of the need to lead credible evidence to prove non-compliance. It states clearly that oral evidence may not be necessary if and only if originals or certified true copies manifestly disclose non-compliance. In this case, the appellants have not demonstrated the originals or certified true copies of documents they want the court to rely on. Given where such documents are tendered in evidence, it is to be shown that they manifestly disclose the non-compliance. On the whole, it is my well-considered opinion, which accords with the views of this court, with the court below, that the failure to transmit result to the IREP did not affect the result of the election. Accordingly, this issue is resolved against the appellants. The second issue is whether the court below was right in its interpretation of the provisions of Section 134 sub 2b and Section 299 of the Constitution of the Federal Republic of Nigeria as amended, in holding that securing 1/4 of the total votes cast in the Federal Capital Territory, Abuja, is not a constitutional requirement for the valid return of a candidate as duly elected President of the Federal Republic of Nigeria. In his argument, the learned senior counsel for the appellants urged this court to interpret the word "and" in Section 134 2B of the Constitution conjunctively and not disjunctively, which will make it compulsory for a candidate to score a quarter or 25% of votes cast in the Federal Capital Territory before he can be President of the Federal Republic of Nigeria. The respondents argue otherwise. My noble lords, on pages 8234 to 8235 of Volume 10 of the Record of Appeal, the lower court made the following decision, and I quote, "As expressly stated in Section 299 of the Constitution for the purposes of fulfilling the requirements of Section 134 sub 2B of the Constitution for the return of a presidential candidate as duly elected, the Federal Capital Territory, Abuja, is to be treated as one of the states in the calculation of 2/3 of the states of the Federation, such that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to secure 25% of the votes cast in the Federal Capital Territory, Abuja, as the second respondent did." End of quote. To be very honest, I do not see anything wrong with the above decision. It is basic that one of the vital concerns of interpretation of statutes is that a court of record should be minded to make broad interpretation, or what is sometimes referred to as giving SEM a liberal approach. A court should give a holistic interpretation to a statute or the Constitution as required by law. Probably I may add that a court must give the Constitution or a statute a purposeful and people-oriented interpretation. What I'm trying to say is that in interpreting the Constitution, or any statute for that matter, a narrow and selfish approach should be avoided. The duty of the court in interpreting statute should be in such a way that it serves the generality of the people and not for a select few. It is tried that the legislature does not intend creating injustice or an absurdity. Hence, the court must always adopt a construction or interpretation which will not reduce legislation to futility and absurdity. See Governor of Kwara State and Dada, citation supplied. Let me drive this matter home. The poster rendered by the learned senior counsel for the second respondent in their brief comes handy. Assuming that a candidate scores the highest number of votes in a presidential election and has 25% or 1/4 of votes in 30 out of 36 states and Abuja, but failed to secure 25% in the FCT, are we saying that he cannot be president? Is that what the Constitution intended? I don't think so. The court below made it very clear when it held that if the framers of the Constitution had wanted to make the scoring of 1/4 of votes cast in the Federal Capital Territory a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. End of quote. The above decision of the lower court is unassailable, and I have no difficulty in agreeing with it. I see no merit in this issue, and I resolve it against the appellants. Issue 3 calls on this court to interrogate the decision of the court below and answer the question whether the lower court was not in error to have expunged The witness statements on oath of appellant subpoenaed witnesses, namely PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, and the exhibits tendered by them on the ground that the witnesses' statements on oath were not filed along with the petition, and that Order 3, Rule 2 and 3 of the Federal High Court Civil Procedure Rules 2019 is not applicable in election matters. He submitted that the interpretation given to paragraph 45B of the first schedule to the Electoral Act 2022 by the lower court in disallowing the testimonies of the appellant's subpoenaed witnesses will only lead to absurdity and prevent petitioners from compelling relevant evidence in possession of an adversary. In reply, the three senior counsel for the respondents in their various briefs submit in unison that the 21 days prescribed for filing the election petition cannot be extended under any guise, and that paragraph 45B of the first schedule to the Electoral Act cannot be enlarged to accommodate witnesses' statements on oath, which were not filed along with the petition. That having responded to the petition based on the facts and witnesses' statements front-loaded, their right to fair hearing will be trampled upon by allowing new evidence through those witnesses when they have no right to further reply. They urge the court to resolve this issue against the appellants. Let me reiterate the already tried position of the law that the election petition is sui generis. That is to say, it is in a class of its own. As was held by this court in Abubakar and Yaradua, this is no longer a moot point. It is different from a common law civil action. In Kalu and Uzo, citation supplied, this court stated clearly that the Electoral Act of whatever version, particularly that of 2022, contains mandatory provisions. Thus, election petitions have certain peculiar features which make them sui generis. They stand on their own and bound by their rules under the law. It was further held that defects or irregularities which in other proceedings are not sufficient to affect the validity of a claim are not so in an election petition. A slight default in compliance with a procedural step could result in fatal consequences for the petition. It has to be noted that rules governing civil proceedings are not the same which govern election proceedings. And where the Electoral Act requires recourse to civil procedure rules, it must be made subject to the provisions of the Acts. My noble lords, a combined reading of Section 285 sub 5 of the Constitution of the Federal Republic of Nigeria as amended, and paragraph 45 of the first schedule to the Electoral Act 2022 shows that the time limit for the filing of written statement on oath of witnesses, the election petition proceedings, is 21 days from the date of declaration of results. As was pointed out by counsel for the respondents, due to the sui generis nature of the election proceedings, amendment to the petition or calling of additional witnesses will not be entertained after the statutory time limit for the filing of petition has expired. Thus, a petitioner cannot present his case in bit, otherwise the respondent's right to fair hearing will be breached. This was the position of this court in Oke and Mimiko, citation supplied. In his contributory judgment in the above case, Clara Ogumbi J.S. retired, made the following decision, and I quote, by paragraph 4, sub 1 and 5 of the first schedule to the Electoral Act, a composite analysis of the contents of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive. It is mandatory and conclusive. In other words, the provisions do not allow for additions, and hence the procedure adopted by the appellants in seeking for extension of time is nothing other than surreptitious attempt to amend the petition. Expressly, there is no provision in the legislation which provides for extension of time. What is more, via paragraph 14.2 of the first schedule to the Electoral Act, the appellants by section 134.1 of the Act have been totally foreclosed from any amendment, which was in fact the hidden agenda promoting the application. Further still, and on a critical perusal of the application, Relief 2 seeks leave to call additional witnesses, to wit AEO. It is pertinent to restate that at the close of pleadings, parties had submitted the list of witnesses who were to testify together with their deposition. The idea, purpose, and intention of the application is suggestive of nothing more than a clear confirmation seeking an order for an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions of section 285 sub 5 of the Constitution and section 134 of the Electoral Act. End of quote. It has to be emphasized that the use of the word shall in paragraph 4.1 and 5 of the first schedule to the Electoral Act makes it mandatory and conclusive. The question may be asked, can a court extend time circumscribed by the Constitution for a party to do a thing he could not do before the expiration of the time? The obvious answer is no. Such provisions like section 85 sub 5 of the Constitution are mandatory, and any exercise of discretion by the court is without jurisdiction and therefore a nullity. In APC and Marafa, citations applied, this court held that applications for extension of time to call additional witnesses and to file additional witnesses' statements after the prescribed period for presenting election petition are not permitted because election matters are time-bound, and by reason of being sui generis, the procedure in handling them are stricter than ordinary civil matters. See also Ararume and INEC citation supplied. Then learned counsel for the appellants had argued that the law does not compel the impossibility and that subpoenaed witnesses should be allowed to testify. But as was argued by the learned senior counsel for the first respondent, A.B. Mahmoud SN, subpoenas are not a tool with which to circumvent the provisions of the law and the effect and purpose of section 285 sub 5 of the Constitution of the Federal Republic of Nigeria and paragraph 4.5 of the first schedule to the Electoral Act 2022. It is on this note that I quote that the decision of the court below to strike out the offending witness depositions cannot be faulted. I resolve this issue against the appellants. Issue 4 orbits around the evaluation of evidence of PW1, PW2, 3, 5, 7, and 22, who were the appellants' coalition agents at the court below. The appellants are aggrieved by the verdict of the court that the evidence of these witnesses were hearsay, thus inadmissible under the rule of evidence. For the purpose of clarity, I shall herein reproduce, albeit extensively, the observation of the court below, which led to the verdicts complained about as follows. Quote, the petitioners, it must be underlined, pleaded in paragraph 4 of the petition that the petitioners had agents in all the polling units, ward collation centers, local government collation centers, and state collation centers in all the states of the Federation and the Federal Capital Territory, as well as the national collation centers. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicate results in Form EC8A. The few agents called were state and national collation agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Kogi State. In paragraph 7, 8, and 11 of his statement, he deposed that from the analysis, he discovered various forms of non-compliance and corrupt practices such as suppression of votes, manipulation of the beavers machines, manipulation of accreditation, intimidation and harassment of voters, massive thumb printing of ballot papers, etc. This witness did not give particulars of these malpractices. There was no forensic report to support allegation of thumb printing at the polling units. In PDP and INEC citation supplied, this court, per agim JCA, as it then was, held that it is only a polling unit agent or a person who was present at the polling unit during polls that can give admissible evidence of what transpired during the poll in that unit. See some cases cited there. In the instant case, PW1 was not a polling agent. He was a collation agent. When cross-examined, he said he would be wrong to say that he was present when all the ballot papers and boxes were manipulated, that he visited only 20 polling units out of the over 3,000 polling units in Kogi State. He admitted that his party had polling agents in all the polling units and that they were still alive. The PW2 is also a collation agent. His witness statement on oath is at pages 213 to 215 of the petition. His statement is similar to that of the PW1. He is Dr. Folarin Sunday Adekunle. He was the collation agent of the petitioner for Ogun State on the election day. Under cross-examination, he said he only visited 19 polling units out of the 5,040 of the polling units in Ogun State. PW3, PW4, 5, 6, 7, 8, 9, 10, 11 are all collation agents. The evidence of these witnesses centered around the events and the duties they carried out by the polling units agents of the petitioners. They agreed under cross-examination that the polling unit agents functioned very well in their units under our law. Specifically, in Section 43 of the Electoral Act 2022, polling agents are permitted to be appointed by political parties for each polling unit and collation center. The wisdom in this is for each of the political parties involved in an election to be represented by its own agents. The duties of an agent are to represent the interests of his or principal, having regard to the fact that no mortal can be in all the places at the same time. The law allows political parties to have their agents at all polling units and collation centers. It is therefore not anticipated by law for any political party to appoint an octopus agent with his tentacles in all the polling units and collation centers. This is humanly not practicable. When therefore evidence is required to prove what happened in any polling unit or collation center, it is only the agent who witnessed the anomaly or the malfeasance that can legally and credibly testified. It follows, therefore, that PW1, PW2, PW3, PW4, PW5, 6, 7, 8, 9, 10, 11, 19, 20, 22, who were state and national coalition agents of the petitioners, can only testify of the events in their units or coalition centers where they voted or acted as agents, and not all over the states of the Federation. The polling agents, as presented in this petition, it must be noted, are not shown to be experts. The issue of their analyzing results of the election at the ward, local government, state, and national level without calling polling unit agents who witness the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify as of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. It follows that the evidence of the coalition agent destruction of voting are inadmissible hearsay and are hereby discounted as end quote. Without reservation, I endorse the above statement of the lower court, which is consistent with plethora of decided cases on the subject, Buhari and Obasanjo, Ladoja and Jumobi, and others cited. From the evidence on record, it is indisputable that PW1, 2, 3, 5, and 7, who were the appellant state coalition agents and national coalition agents, were not present in all the polling units, which results they have disputed, which means that their evidence in respect of all the polling units, other than the ones that they were present, were clearly hearsay. They were most likely informed by the polling unit agents who were alive but failed to testify. I must say that the above statement of the lower court had nothing to do with the court's failure to ascribe probative value to documents put in evidence pursuant to Section 137 of the Electoral Act 2022 and paragraph 46(4) of the first schedule to the Electoral Act, as vehemently submitted by the appellants. Indeed, the point is instructive in view of the fact that the court had earlier on page 8,102 of the record rejected and overruled the third respondent's preliminary objection, seeking that documents tendered by the appellant be expunged for being dumped on the court. The finding of the lower court in discountenancing the evidence analysis of PW1, 2, 3, 5, and 7, same being based on hearsay, cannot be faulted. More so, the appellants have not presented any argument to warrant the interference of this court with the finding of the lower court. The issue, again, is resolved against the appellants. Issue number 5 is whether the lower court was not in error in striking out several paragraphs of the petition and the replies of the appellants on the ground of vagueness and lack of specificity and for being new issues, mere denials, or being repetitions. Well, this issue relates to the ruling of the court below on the first respondent's preliminary objection, seeking an order of court striking out 31 paragraphs of the petition on the ground that they were vague, generic, imprecise, and lacking in specificity to elicit reply from it, and contrary to paragraph 4.1 of the first schedule to the Electoral Act 2022. The court, after scrutinizing each of those paragraphs in a well-considered ruling, struck out 10 paragraphs, namely 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 for being vague, imprecise, and lacking in particulars. For the purpose of clarity, the court held on page 8025 to 8026 of the record as follows. The sum total of all the foregoing is that while paragraph 129 and 133 of the petition are liable to be struck out for non-joinder of necessary parties, to which Messrs. Adejo and Governor Yahya Bello of Kogi State, accused in the petition of committing electoral malpractices, paragraph 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack of particulars, and so fall short of the requirements of paragraph 4 sub 1b of the first schedule to the Electoral Act 2022. They are therefore all others struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 110, 111, 112, 113, 14, 115, 116, 118, 119, 120, 122, 125, 130, 134, 138, 139, 140, 141, 42, 145, on the other hand, are in order and properly pleaded, end of quote. Picked by the above ruling, the appellants now seek the interference of this court on the ground that their averments were sufficiently detailed. They also question the decision of the court, striking out their replies to the respondents' replies to the petition. For instance, as touching on the disqualification of the second respondent from contesting election for the office of president, which particulars were supplied in the appellant's reply. It is instructive to note that in paragraph 146 of the petition, the appellants simply averred that, quote, the second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, end of quote. They did not supply the particulars of the threshold, which they perceived disqualified the second respondent from contesting the election, as enumerated in section 137 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Howbeit, in their reply, the appellant ruled out monstrous particulars of disqualification by reason of dual citizenship, allegation of being an ex-convict in a USA district court, having forfeited to the USA the sum of $460,000 in a drug-related case, Note that these particulars referred to as further details were brought in by the appellants at the time when the respondents had lost their right of reply, which in essence offends the cardinal principle of fair hearing expressed in the Latin maxim audi alteram partem, meaning let the other side be heard as well. Paragraph 4 sub 1 of the first schedule to the Electoral Act 2022 provides that an election petition shall A, specify the parties interested in the petition, in the election petition, B, specify the right of the petitioner to present the election petition, 3, state the holding of the election, the scores of the candidates, and the person returned as the winner of the election, and 4, state clearly the facts of the petition and the ground or grounds on which the petition is based and the relief sought by the petitioner. It is clear beyond a peradventure that the requirements of the law is as provided above, is that the petition must demonstrate with specificity the complaints of the petitioner and the relief sought from the court. It gives no room for vagueness and imprecision. This is in line with the rule of pleading, that where an averment is not supported by evidence, the averment is deemed abandoned. For, in keeping with the audi alteram partem rule, to prevent surprise or ambush on the defendant, it is the plaintiff's claim that will enable him to file his defense. See Wayne West Africa Limited and Econife citation supplied, Akonde and Adisa, and another citation supplied, PDP and INEC citation supplied. It follows, therefore, that a petition must be detailed and comprehensive on material facts depending on the relief sought, and not evasive or vague, so as to elicit a response from the respondents. Indeed, by the provision of paragraph 16, sub 1A of the first schedule to the Electoral Act 2022, the Act frowns at the introduction of new facts, grounds, or prayers tending to amend or add to the averments of the petition in the petitioner's reply. In fact, a petitioner is only required to file a reply in answer to new issues or facts which may be raised in the respondent's reply, which were not dealt with in the petition. This means that where there are no new issues or facts raised in the respondent's reply, there would be no need for the petitioner's reply. See Oni and Oyebanji, citation supplied. I have critically considered the arguments of parties contained in their respective briefs of argument vis-à-vis the record of appeal. The affected paragraphs of the petition relates to allegation of wrongful cancellation of polling unit results in various local governments in Sokoto State without particulars, manipulation of results in unspecified polling units in some local government areas of Kogi State, wrong results entered for the appellants in unspecified polling units in Borno State, criminal allegations against Honorable Adejo and Governor Yaya Bello without joining them as parties to the petition, open-ended allegation of disqualification against the second respondent, and tying critical allegations of corrupt practices in the election to a statistician report prepared by one Samuel Odutan, that's PW21, without serving the said report on the respondents along with the petition to enable them respond thereto. I am unable to agree with the appellant's argument that the lower court was wrong to have struck out the affected paragraphs for disclosing no particulars, together with some replies in the appellant's reply brief, which sought to bring in new evidence through the back door. I uphold the decision of the lower court striking out the affected paragraphs and replies of the appellants for being vague, imprecise, lacking in particulars, and seeking to ambush the respondent via the petitioner's replies. The ruling of the lower court is unassailable, and this court will not interfere. This issue, again, is resolved against the petitioners. Issue 6 is whether the lower court was not in error in its evaluation of the evidence of the appellant witnesses on the burden of proof and clear admission against interest made by the first respondent. This issue turns on the averment of the first respondent in paragraph 8 of his reply to the appellant's petition, that the appellants in this case won the contested election in 21 states out of the 36 states of the Federation, namely Adamawa, Akwa Ibom, Bauchi, Bayelsa, Borno, Delta, Ekiti, Gombe, Jigawa, Kaduna, Katsina, Kebbi, Kogi, Kwara, Nasarawa, Niger, Osun, Sokoto, Taraba, Yobe, and Zamfara states. The appellants contend that such averment is tantamount to admission against interest by the first respondent. They therefore question the declarations to return of the second respondent as the winner of the said election. On its part, the first respondent contended that its said admission is of no consequence, having regard to the fact that the appellant scored 6,984,520 votes, as against the second respondent, who scored 8,794,726 votes. That in determining the winner or loser in an election to the office of president, the number of states won by a candidate merit any consideration except in the context of geographical spread and ensuring compliance with the constitutional requirements. In its evaluation of evidence on the issue, the court below on page 8238 of the record had this to say, quote, "The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So, where the complaint in an election petition is that the candidate returned did not poll majority of the highest votes in the election to be returned, as contended here by the petitioners, not only must the figures disputed be pleaded, the figures of votes the petitioner perceives as correct figures of the election ought to and must be pleaded." The court went further to hold on page 2854 of the record that, quote, "Section 134 sub 2 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her, in the absence of any rival or alternative result placed before this court by the petitioners, that the second respondent, who scored 8,794,726 votes as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election," end of quote. The above statements, qua holding of the court, represent the correct position of the law, and I wholly endorse them. I have earlier in this judgment resolved the issue of electronic transmission of results, which is the main thrust of the appellant's contention in this appeal. I shall not revisit the point under this issue. On the contention that the first respondent's averment that the appellant won 21 states out of 36 states of the Federation, thus constituting an admission against interest, the position of the law is well settled, having regard to who can be declared winner of a presidential election in Nigeria. Section 134 sub 2 of the 1999 Constitution makes it explicit that, quote, "A candidate for an election to the office of president shall be deemed to have been duly elected where there being more than two candidates of the election, A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja," end of quote. In this appeal, the issue before us is not who among the candidates won in the majority of the states of the Federation, which is debatable, but who scored the highest number of votes at the election. I have strenuously combed through the respective briefs of the parties vis-à-vis the record of appeal. I am unable to find any alternative figure put forward by the appellants as their rightful votes scored in the election, other than the scores presented by the first respondent, INEC, showing that the second respondent scored the highest number of votes. It is presumed correct. In the case of Abubakar and Yaradua, citations supplied, this court held that, and I quote, "Election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption," end of quote. See also CPC and INEC, Buhari and Obasanjo, Hashidu and Goje, all citations supplied. Following from the above, it is clear that the appellants, having not put forward their perceived rightful score to rebut the result put forward by the INEC, the law presumes the first respondent's version as correct. It would not matter whether the appellant can prove having won more states or if the first respondent admits that much. The figures before us show that the second respondent won the highest number of votes and was accordingly returned elected. From whence, therefore, would we manufacture evidence to support the appellant's claim that they scored the majority of lawful votes cast at the election, or that there was non-compliance with the Electoral Act, which affected the credibility of the election? Nowhere, definitely not from the evidence on the record. And that is why this issue is resolved against the appellants. Finally, let me say a few words concerning issue number 7, which is whether the lower court was right in its use of disparaging words against the appellant in its judgment, evincing hostility and bias against the appellants, thereby violating their right to fair hearing and occasioning grave miscarriage of justice. I have read the judgment of the court below, and I've seen the context which those words were used, and it is my view that they were not meant to disparage the appellants or their counsel. As judges, we are trained to be temperate in our use of words, and we shall continue to do so. Litigants are advised to trust the court whenever their matters are before it. It is very unbecoming these days that while a matter is pending in court, litigants engage in press conferences, analyzing the case, reaching conclusions. Based on this, some of their followers send threatening messages to judges and justices. Matters in court are said to be sub judice, and as such, parties, and probably their counsel, should refrain from media trial and media judgments. I need not say more on this. A word is enough for the wise. This issue has nothing positive to offer the appellants. On the whole, having resolved all the issues against the appellants, it is my view that there is no merit in this appeal, and it is hereby dismissed. The judgment of the court below, delivered on the 6th of September 2023, affirming the election of the second respondent as the duly elected President of the Federal Republic of Nigeria, is hereby affirmed. I shall make no order as to costs. My learned brother on my right will deliver his judgment.
Having had a preview of the judgment of my learned brother, John Ian Ikoro, JSC, availed me with a copy of the said judgment just delivered in SC/CV/935/2023. Atiku Abubakar and the Independent National Electoral Commission and others. I completely agree with the critical analysis of both the oral and documentary evidence presented before us in this appeal. Therefore, I agree with my learned brother that the motion of the appellants filed on the 6th of October 2023 for leave to the appellants to adduce fresh or additional evidence is devoid of any merit. I also dismiss the same. On the main appeal, my learned brother resolved all the issues, the 7 issues against the appellant. I therefore agree with him that the issues in the main appeal are devoid of merit, and the appeal is accordingly dismissed.
Every major news story is with many perspectives and layered with different levels of impact.
Hello. What time did this happen? We will be right there.
At TVC News, we follow the big and major news, gathering the facts, witnessing the outcome.
I am here live at the aftermath of the approval of the new national minimum wage.
We are TV Station of the Year, not just for breaking news, but for being first, fair and accurate. TVC News, first with breaking news.
Politics is defined as getting what, where, when and how. But in the mix, many things come to play to shape the political fortune of any country.
Mr. Honorable Minister, that's how you misinform the public.
From the political actors to the electorate, campaign to voting, from debates to policy decisions, big events happen to engage us in constant conversation.
That's what we're looking for. Not some people who are talking about ethnicity. No.
Who is on your mind?
Don't worry.
Join me every day on Politics Tonight, where we dissect issues that shape our political destiny. Politics Tonight, weekdays on TVC News.
Doubt and fear doesn't occur at the canvas, it shows in the canvas. It shows the conation of raw earthen material slabbed, stroked and molded at a pace provided by the doubt and fear. Every move way in the struggle of one to the other, merging the past to the present, brushstrokes of colors seen but not known. For when the wailing stops, the pieces settle down in abject beauty erected for a century of a century. Speaking, advocating, protesting as the arts are meant to be.
Information is power, information is security, information is knowledge. On Labor Lens, we believe that working people around the world have real questions of their own. They want to know how the world of work operates, what it means to the employer of labor, how policies affect workers in the workplace. On Labor Lens, I ensure we engage effectively the organized labor, organized private sector and government to get out of them information workers are in need of. I am Sharon Ijason, asking questions that make you get sense of the workplace.
Business lives on the fast track of numbers. Business is a strange world where low numbers mean something different. And its currency are speed and time. Finding the open doors of Main Street is not just good business, it's the start of the business. Join us every weekend on Business Week.
It's not your regular show. It's an online interactive session where we share my views on the everyday issues that cut across politics, security, health, current affairs, governance, and so much more. I am passionate about our country. I choose to support any conversation geared towards building a better Nigeria. I am Abajide Kolaji Otitoju. Join me every Saturday on TVC News YouTube channel as I discuss Nigeria and the world at large on the show Issues with Jide.
Every 1 hour, 86 migrants enter Lagos State. It is a beehive of activities. Every second counts in this city that never goes to sleep. There is always something to talk about. We go the extra mile to tell the story of Africa's 5th largest economy. We track happenings on land, on waterways, and in the air. We go against all odds to ensure that you are heard.
25% of the entire spread of Lagos is covered with water.
I'm Adedoja Salamadeni. I live in Lagos.
The opportunity of a preview of the judgment that she has just delivered. I must say that I have read that judgment, and I'm very much content and appreciative of the far-reaching erudite reasoning and the conclusion that have so far been reached in the lead judgment. I concur with the highest sense of responsibility with the reasoning and conclusion reached therein. With particular regard to the interlocutory application, thereby urging upon this court to grant leave to the appellants to procure and transmit and adduce fresh or additional evidence at this crucial point in time of the appeal. I concur most assiduously with the conclusion that has been reached in the judgment of my learned brother that such an application is grossly unmeritorious, thus ought to be dismissed, and same is accordingly hereby dismissed by me. And as for the substantive appeal itself, which has been predicated upon a total of 7 issues, I agree entirely with the reasoning eruditely expressed by my learned brother that each of the 7 issues that has been canvassed and argued by the appellant are grossly unmeritorious, thus ought to be resolved against them. Without much ado, I hereby accordingly dismiss the appeal for being grossly unmeritorious. As usual, it is not the time for us to read elaborative judgments. Just like my learned brother said, 12 hours. We're not going to do that because learned counsel representing the respective parties in this appeal will have every opportunity to be served with the complete judgments of each and every justice of this panel in due course. Because constitutionally, we have a total of 7 days within which judgments must be served on the respective learned counsel that appeal. Thank you very much.
My Lord Jaro, read your judgment.
Thank you. Well, I've had the privilege of reading before now the lead judgment delivered by my learned brother, John Ian Okoro, JSC. His Lordship has ably considered and resolved all the issues in contention in the appeal, as well as the application. I agree with the reasoning and conclusion reached therein to the effect that the appeal is bereft of merit and deserves a dismissal. The application, too, is not meritorious. Accordingly, I dismiss the application and the appeal. That is my position.
My Lord Abubakar.
I thank my Lord the Presiding Justice, Honorable Justice John Ian Okoro, for granting me the privilege to read in draft the lucid and illuminating leading judgment just delivered in this appeal. I start with the application. The application seeking to adduce additional evidence or fresh evidence, I also find it lacking in merit. The application is frivolous and vexatious. It deserves to be dismissed, and it is hereby dismissed. Now, coming to the substantive appeal, I find no merit in the substantive appeal. It is also dismissed. On the whole, therefore, the appeal is dismissed and the judgment of the lower court is affirmed. Parties in this appeal shall bear their respective costs.
Yes, Iroko. Agim, JSN.
With the kind permission of the learned presiding justice, let me also express my view. I had a preview of the judgment delivered by my learned brother, Lord Justice John Ian Okoro, JSCFR. I completely agree with the reasoning, conclusions, decisions, and others therein. And I must remark that it is bristling with commendable erudition. Let me, however, say maybe one or two things, since we will have opportunity, you will have opportunity to have our views. That the deposition is, for this additional reason, inadmissible. So if a document is inadmissible, you cannot ask that you should be allowed to bring it in as fresh evidence. A reading of the deposition exposes that it is not authenticated by the seal of the authority before whom it was issued. A deposition from another country to be used in Nigeria should prima facie bear features of authentication, such as the official seal of the court where it is sworn, if it is the court, or if it is before a notary public, his seal or signature, or if sworn before a person legally authorized to take the seal, or if sworn in the Nigerian Embassy, High Commission, or Consulate in that country, the signature of the officer authorized to do so, and the seal of the Embassy, High Commission, or Consulate. Such authentication is an assurance of the origin and authenticity of the foreign disposition. In our present case, the certified shorthand reporter, before whom the deposition was made, did not authenticate the deposition with her seal. She merely signed a certificate of reporter bearing her name and number, page 126 of Exhibit C. Being a deposition from another country, it cannot be used in Nigeria without authentication. The authentication of the oath administration is mandatory. I have wondered why the deposition said to be made pursuant to the 3rd October 2023 order of the United States District Court for the Northern District of Illinois in case number 23 CV 05099 for use in a foreign country was not made before the court in the said proceedings. And if made elsewhere in the law office of the first appellant's attorney, why was it not filed in the above-mentioned court? Because of the peculiar circumstances of this case, and adopted as a deposition ordered to be made by the court, so that it can form part of the record of that court to enable the court issue it as part of its record, also authenticate it with the seal of the court and the signature of the relevant officer of the court. Page 1 of the deposition is headed in the United States District Court for the Northern District of Illinois in reapplication of Atiku Abubakar for an order directing discovery from Chicago State University pursuant to 28 U.S.C. 1782 number 28 CV 05099. This gives the impression it is a process of the District Court, or that the deposition, though made outside the precincts of that court in a private law office, is part of the proceedings in case number 23 CV 05099. If it is indeed a process of the said District Court, or forms part of the proceedings in case number 23 CV 05099 before it, then it ought to have been authenticated by the official seal of the court and the signature of the relevant officer certifying it as a true copy of the part of the record of the court in case number 23 CV 05099. Without such authentication, a deposition cannot be used in the Nigerian court as part of the proceedings or in the said U.S. District Court. And I've continued to wonder why the college, why the appellant did not use the advantage of the order of the District Court that the college produced documents and a deposition concerning those certificates. Why they didn't use that advantage to secure a letter from the college under its letterhead, seal, and signature, disclaiming the certificate presented by the second respondent to INEC as not one issued by the college. That was not done. Instead, they resorted to this deposition, which has no features of authentication, thereby rendering it spurious and inadmissible. I agree with the able manner the lead judgment has dealt with it. I agree totally with all the reasons given in that decision as to why such an application should be refused. And it emphasizes one point. It was obvious to all, including those who brought it, that it was going nowhere. Then the question is, why was it brought? And I agree with my Lord when he described it as a vexatious process. I dismiss the application too. I go to the appeal. I agree completely with the lead judgment. I cannot say it better than that. It was a real brilliant expose on all the issues raised. Let me also join my Lord Garba to talk about a question of Abuja and 1/4 of the votes there, that the candidate must win. They view that the provision of the Constitution should be applied in such a way that the votes in Abuja must be won. 1/4 of the votes must be won by a candidate before he can secure victory in election. To me, violates a fundamental principle of constitutional interpretation, that it must be interpreted to protect the spirit of the Constitution. And if you look at our Constitution, it promotes egalitarianism, equality. So it must be applied in such a way as to protect the equality of the votes in all the entities, and not otherwise. I will expand on that in my judgment. So I do not agree with the interpretation placed upon it. Attractive as it may be, but we must bear in mind that there is no jurisdiction in the world where a constitution is read in isolated patches and given meaning that should have, very narrow meaning that should appeal to certain sentiments. No, you apply it as a whole, reading it completely together, so that you rely on one part to get a meaning in another part, that the words can truly support the words used in that provision. That is how to read a constitution. Remembering that it is dealing with a dynamic system, a human society. For these reasons, I also dismiss the appeal. I also agree that the parties should bear their costs. Thank you very much.
Thank you, my lord. We are now left with the next appeal. I call the next one.
SCCV 937-2023. Mr. Peter Gregory Obi, Labour Party, Appellants, Independent National Electoral Commission, INEC, Senator Bola Ahmed Tinubu, Senator Shetima Kashim, All Progressives Congress, APC respondents.
Appearances.
The Lordship, my name is P.I.N. Ikweto. My Lords, unfortunately, we have a type list of counsel, and by the time my colleagues brought it to the registry, they were told it was late. If your Lordship allow me, can I submit that list?
Please, sir, submit it.
Thank you, my Lord, sir. And my Lords, with respect,
judgment day, you don't go late to court.
I was here before. I was here by 8 o'clock, sir.
So that you won't be late when God will be giving judgments.
Oh, my Lord, on the day of my own judgment before the Lord, I will be there alone. So I will not be late there.
So,
and I'm sure you will accept me when I get there, sir.
God will accept you.
I'm sure you will.
I pray it should be so.
Amen, sir. My Lord, I want to say that my name is P.I.N. Ikweto, and your Lordship, with respect, we have, in line with your Lordship.
I think we should start calling you Saint Ikweto.
My Lord, I cannot be while still on earth. Yes, sir.
Until you die.
While still on earth, I cannot be. I'm a sinner.
Let's find a place and discuss that.
I don't please. My Lord, I don't know where we can discuss that, sir. My Lord, I will take the liberty to tick the names of my colleagues who are with me.
Azinge.
Number 3, Dr. Mrs. Valerie Janet Azinge, SN. Number 4, my Lord, Alex Ejesime, SAN.
Azinge.
Yes, sir. Azinge is number 3, sir.
Yes.
Number 4, my Lord, is Alex Ejesime, SAN.
Where is Azinge?
My Lord, Azinge is just beside me here. She's been here all morning with me.
Azinge used to be black. I don't know why she's white today.
No, she's always been fair complexion. Always. Yes, sir. The husband is dark complexion.
Okay, it's the husband that is dark.
As a Lordship, please. Yes, sir. But she's been fair complexion all along.
It's okay. You're welcome.
Yes, my Lord.
Leonard S.N. Equator, did you say Valerie is number 3?
My Lord, on the list, she's number 3.
But she's number 2.
She's not, yes, sir. Yes, sir. I just want to make it easier for my Lord, sir. The next, my Lord, is Mr. Alex Ejesieme S.A.N.
Yes. Chike.
My Lord, there's a Chike A.O.B. Esquire.
Yes.
And my Lord, lastly, and in compliance with my Lord's directives, Ejiofor Onwaso Esquire. The Lord's appearance with due respect is for the appellant in this appeal.
Yes.
May it please my lords. I am Sir Stephen Adehi. I am number 2 on the list.
Where is your list?
We submitted a list this morning, my lord.
Stephen
Adehi, my lord. Okay. Sir Stephen Adehi.
Need that thing. Adehi.
Yes, my lord.
Yes.
I appear with my learned friends of the inner bar.
Yes, yes.
Al Hassan A. Umar, S.A.N. is number 4 on the list.
Umar.
Yes, my lord.
Yes.
And number 7 is Wendy Kuku, Esquire, my lord.
Yes. Yes.
Number 8, Jamiu Aguru, Esquire.
Where is Jamiu Aguru?
And finally, number 10, Z.U. Obansa, Esquire. Our appearance, my lord, is for the first respondent. May my lords be pleased.
Is that for the... Yes? Tell those guys, tell them that this thing can amount to contempt of court, so they should be careful.
My lord, the last person on our list, my lord, is actually number 9, Amira Hamisu, not Obansa. Number 9.
Who?
Amira Hamisu, Esquire. Yes, my lord. Not number 10, my lord. Thank you very much, my lords.
1, 2, 3. Amira. Hamisu. Yes?
If it pleases my noble lords, my name is Akintola Makinde, and I appear with my colleague, Okpe Muritala. Your lordships, we submitted a typewritten list in the morning. Very respectfully, our appearance is for the 2nd and 3rd respondents. We are very grateful, sir. Okpe Muritala, my lord, is number 2 on the list here.
Yes.
We are very grateful, sir.
Yes. Yes. Yes.
Appear with me, I'm learned friends. My lord, I'm sorry, the next name is not on the printed list which is submitted.
Let me, okay, yeah.
Professor Abdul Karim Kana. And Abdul Wahab Abayomi. We all respectfully appear for the fourth respondent. How much obliged, my lord?
For the fourth respondent.
Respectfully, my lord.
Yes, well, in this appeal, we have, during conference, noticed that issues number 1, 2, 3, 5, 6, and 7 in this appeal have been dealt with in Atiku's appeal. It is the decision of this court that this issue shall abide the outcome of the issues as resolved in Atiku's appeal, mutatis mutandis. As for issue number 4, which has to do with double nomination, which was not in Atiku's appeal, it is the view of this court that this issue, having been dealt with by this court in SC/CV 501/23, which judgment was delivered on the 26th of May 2023, this court cannot allow the matter to be re-litigated in this very court. There must be an end to litigation. For us to sit down now and talk about when this man resigned or did not resign, when they did a fresh conference or fresh primaries to replace him, which we have done before. We are not going to do it again. This matter ought not to have come here. When the matter was pending at the trial court, this court delivered that judgment. If you read the judgment of the lower court, they mentioned it, that Supreme Court has settled this matter. And that should have been the end. You now bring this issue of double nomination for us to sit on it and write another judgment. This is not how it should be. This appeal lacks merit and is hereby dismissed. My Lord, to my right, Abaji.
I agree with my learned brother, Justice John Ian Okoro, that this appeal, number SCCV 937/2023, Mr. Peter Gregory Obi and the Independent National Electoral Commission lacks merit and it is also dismissed by me.
My Lord Garba Jesse.
I also totally agree with the lead judgment that this appeal substantially canvass the same issues with the appeal number 935/2023, which this court has very comprehensively dealt with, and there is no need for us to repeat ourselves because the issues are the same. The only issue that's different, like pointed out by my learned brother PJ, is that about double nomination, which you have settled, and we do not intend to reopen it again in this appeal. On the whole, I also join the lead judgment to dismiss this appeal for lacking in merit.
My Lord Salawa.
Having had the privilege before now of reading in draft the judgment prepared and delivered by my learned brother Okoro Jesse, I cannot but concur with the far-reaching reasoning and the conclusion that has been postulated in the judgment to the effect that the instant appeal lacks merit, thus ought to be dismissed by this court. Having associated myself with that reasoning and the conclusion, I have no hesitation whatsoever in dismissing the appeal. Appeal dismissed.
My Lord Jauro.
Well, I had the advantage of reading in draft copy of the lead judgment just delivered by my learned brother John Ian Okoro JSC. I entirely agree with the reasoning and conclusion contained therein that the appeal is devoid of merit and it ought to be dismissed. Consequently, I join my brother in dismissing the appeal.
My Lord Abubakar Jesse.
I also had the advantage of reading in draft the judgment of my learned brother Ian Okoro JSC, and I am of the view that the appellants have nothing useful to urge this court. The appeal lacks merit, and it is hereby dismissed by me.
My Lord Agim Jesse.
I had a preview of the judgment delivered by my learned brother, Lord Justice John Ian Okoro. I completely agree that this appeal lacks merit and it should be dismissed. I hereby dismiss it.
Thank you all for listening. The two appeals, I think we have concluded our job today. What remains is for us to go and rest. Thank you very much. We shall rise.
Well, let me say clearly that it is instructive that the decisions were unanimous, without any dissenting voice. Like the judge said, all litigation must come to an end. They addressed all the issues, about 7 of them, and those issues were, the judgments on each of the issues were clearly unassailable as far as I'm concerned. So for me now is the time for us all, every Nigerian, particularly the president, to roll up his sleeves and continue with the governance. This has been a distraction. The litigants exercise their rights to go to court, but that has come to an end now. We now have to all come together as one country, one people, and move ahead and take this country where it rightfully should be. We're happy, we're excited.
So you said coming together, does that mean that you'll be extending the hands to the PDP and the Labour Party? Although the APM's appeal was dismissed, but would the president be extending the hand of friendship or sportsmanship to the other political parties?
Listen, we should listen carefully to the judgment. The judgment was very sound by any objective raggedy person, supported with facts, with cases, statute. The president, if you know him very well, is a Democrat. It's not now that he's extending his hands of fellowship. He's always done that. He will continue to do that. And we will continue to do so on his behalf. Governance is about everybody. It's not about a party. It's not about an individual. If we do not come together now, then we'll have ourselves to blame. Opposition is not, you don't oppose for the sake of opposition. Elections are over. Litigation is over. All litigation must come to an end. Now is the time for governance. Distractions over. So yes, Mr. President, the APC, and all rightful thinking members of the society must come together, no matter what party you belong to address the issue of governance. Thank you very much.
We're glad that this puts an end to all litigation and a closure to all the speculations and all that. Mr. President, in his magnanimity, I'm sure will now again reach out to all to join hands with him in his renewed hope agenda. APC was his platform, but the Nigerian state is where he's president of. So this is not just a victory for our party APC, it's a victory for the country. And we want to salute the judiciary, starting from the Supreme Court, the appeal court. Their judgment was very detailed, it was very meticulous. They laid the foundation for the Supreme Court judgment. I want to salute the judges of the Supreme Court as well. They were straight on it. And I believe that this judgment would be seen worldwide as that which is in line with global best practices in law. I want to salute them again because, they are the bastion of hope for everybody, including the common man. And this is a victory for democracy. Opposition can now go and rest. If they indeed mean well for this country, I expect that after today, they will call President Bola Ahmed Tinubu, they will congratulate him, they will now sit down and fashion out how to join hands with him in ensuring that indeed we are going to achieve our pride of place in the Committee of States across the entire world. Once again, I congratulate President Bola Ahmed Tinubu for this victory, and I congratulate APC, and I congratulate Nigeria. Thank you very much.
Yes, just one question.
The court today said that the FCT has no special status. As the minister of the FCT, what do you have to say about that?
You don't understand when he said FCT has no special status. What he said that in terms of calculating or having the status quo, you must not win FCT before you are declared president of the Federal Republic of Nigeria. That FCT is like another state. So that you don't need to say, oh, if you don't win FCT, therefore you cannot be declared. That's what he said.
So you must be sat with the APC crew. Can we dare say that you have moved to the APC?
I didn't come with APC crew. And in the court here, I don't know where they said APC and PDP. I came here as somebody who's interested and somebody who wanted the country to move forward. So I congratulate Mr. President, and I think that this has come to the end. No more speculation. So Mr. President can focus and do what he's supposed to do for Nigerians. Thank you.
Thank you very much.
Mr. Chairman. Yes, please.
Well,
and what is your advice to your opponents?
Well, you see, this is a developing democracy in a developing nation, so you expect such distractions to occur. But I believe we fine-tune our laws, especially electoral laws, and we believe we shall come to the mature stage that we are expecting. Pertaining to acceptance of this verdict, I urge our colleagues, politicians, to accept it in good faith. And also I have to use this opportunity to congratulate politicians, to congratulate the leaders of the opposition political parties, because it is better for them to resort to judiciary, which they have done so, rather than going.
Every major news story is with many perspectives and layered with different levels of impact.
Hello. What time did this happen? We will be right there.
At TVC News, we follow the big and major news, gathering the facts, witnessing the outcome.
I am here live at the aftermath of the approval of the new national minimum wage.
We are TV station of the year, not just for breaking news, but for being first, fair and accurate. TVC News, first with breaking news.
Thanks for joining us on TVC News. We've been bringing you live coverage from the Supreme Court, and you get it there. Most of the things that have actually transpired on the, from the Supreme Court. We're bringing you live coverage from there, which has just been delivered by a panel of 7 justices headed by Justice Inyang Okoro. The Supreme Court dismissed the appeal filed by the People's Democratic Party challenging the victory of President Bola Tinubu. And in a unanimous decision, unanimous judgment, a 7-man member panel led by Justice Inyang Okoro dismissed the appeal for lacking in merits. The panel of justices also dismissed the appeal filed by the Labour Party. Then the matter is an appeal in presidential election. So many things there that we also need to talk about. The reason why you were able to watch this earlier today was the fact that it was also allowed the Chief Justice of Nigeria, Olukayode Ariwola, approved the live transmission of judgment. So everything that went on, it can also, according to the court, it can also be assumed that the jurisdiction can be conferred on the court by parties. So the Supreme Court said it cannot do what the Court of Appeal did not do in many of these issues which they brought up. And also the Supreme Court said it cannot also invoke Section 22 of its Act after the 180 days for the trial courts deliver judgment has lapsed. Then a petition cannot amend its petition after the 21 days allocated for filing petition, which has lapsed in line with Section 134, subsection 7 of the Electoral Act. One of the petitions, according to some of the petitions brought by the PDP to the Supreme Court, which the Supreme Court described as shocking, is that the lower court no longer has the jurisdictions to entertain any fresh applications. It makes it clear that the Supreme Court has no jurisdiction to entertain same. And he also added that there is nothing in Section 285, subsection 6 of the Constitution that suggests that the Court of Appeal can hear election petitions without time limits. So the argument by the PDP that the Court of Appeal is not caught by the 180 days provision, since the Court of Appeal was not described as a tribunal in the Constitution, is false. So the Supreme Court then said that it can't accommodate a case of forgery. So, it gave instances from the citations from similar cases and incidences from previous rulings. One of it, which we said that the application cannot be granted, the court cannot admit the deposition, and also said that no issue for determination by the appellant point on certificate forgery. And all of this is also, the justice asked pertinent question from the PDP council, saying that, asking that what attempt the PDP make in obtaining the president's certificate from when INEC in June 2022 published the president from EC9 to 21st of March 2023 when they filed their petition. They also talked about the issue of electronic transmission of results, which is said that the only time when electronic transmission of result becomes relevant is when there is no written hard copy of the results. So the petition seeking to nullify an election on grounds of non-compliance must establish that. So in the judgment of the Court of Appeal, the appellants abandoned their duty to prove compliance. And on, quite interesting conversation that talked about the 25% of the votes, which it also clarifies the issue of the status of the FCT, saying that it doesn't enjoy special status. In summary, that there is this striking out of the PDP's weakness as well. That for the Labour Party, it was also the Supreme Court also adopted the position held in the appeal filed by the PDP in the appeal filed by the Labour Party, which is dismissed in the appeal filed by the Labour Party. So they said the only difference in the two appeals is the issue of double nomination, which Labour Party alleges the Supreme Court has already decided on that issue, according to them. So all of these and on, so many talking points to bring to your hearing, some of which you saw live, what we are giving you the live transmission of what transpired in the courts today, with using simple expressions, simple language, without legalese, to burden Nigerians. Let me bring this to my colleague in the studio, Ayodele, who has been monitoring the Supreme Court's judgment all day, to have one or two conversations as regards this. Ayodele Ozubako, it's good to see you this morning.
Thank you.
It's been a long time coming. It's been a long time coming. We've been looking forward to today, how it's going to pan out and all of that. With all of this hulabaloo, what do you think this judgment bring to the fore now?
I wasn't expecting anything different. I've been covering elections since 1999, and those elections have been have been subject to litigations, and they've gone to Supreme Courts right from the time of Ephraim Akpata, Abel Gubadia, Morrissey. Those elections, they've gone as far as going to the Supreme Courts, and the only thing here is that when this is one of the most keenly contested elections, that you have live viewership for the Court of Appeal and the Supreme Court verdicts that everybody has been monitoring. So it's done and dusted. What is there is what Justice Okora just said. There should be an end to litigation. Now, governors should start. What they've just done today is just to affirm it, that the February 25th presidential election was actually won by Bola Ahmed Tinubu and of the All Progressive Congress. Every other loopholes, before now, the Atiku Abubakar tried to go to the Chicago State University, and then the Supreme Court, with the verdicts now, it's just like, forum shopping. And the small nuggets from what you read earlier, that the Supreme Court rejects the Atiku Abubakar's application to introduce fresh evidence. That means you can't do it at this stage. There's been a law to that extent that you can't do it at this stage, and we thought Atiku Abubakar wanted the Supreme Court to introduce the doctrine of necessity to be able to allow him to bring this application at this stage. But lo and behold, it didn't happen, and Justice Okoro, they stood their grounds. The second one is that the Supreme Court dismissed Atiku Abubakar's petition against the IREV portal, and it went further to dismiss the Atiku Abubakar's 25% in FCT case and say no need for the 25% for the Supreme Court. And the Supreme Court also affirmed that the IREV portal is not a collation system, that INEC will still have to rely on that Form EC8A. That's why the elaborate process of going from EC8A, when at the polling unit, when you get to the ward level, it comes EC9, and so on and so forth, that there's been a kind of elaborate measure by the Independent Electoral Commission to actually make what we call a contingency plan for anybody to view these results. And they weren't able to prove that that contingency plan was altered in any way. So the issue of IRF becomes a backup thing. It's not a collation center. That's what the Supreme Court
Even though the INEC before now also made it known that, well, it is not transmission, as people were saying. It is actually uploading. Trying to make us understand
semantics,
the correct word.
Yeah, semantics. Yeah. So INEC has been able to tell us that the petitioner, they've not been able to prove it, that substantially that this has affected what has happened with Form EC8A, and that it was altered in any way, that what is there is not different from the election. And they went further to say Atiku Abubakar couldn't establish the case of fraud against President Bola Ahmed Tinubu, and that's Supreme Court ruled that Tinubu truly won the election, and they dismissed Atiku's petition. And one thing that is instructive there, that 7 judges, it was unanimous. I was looking forward to see a dissenting judgment, and I would have picked some substance, and anything that the dissenting judgment was saying would have loved to see. But it's strange that for the first time, we're going to see unanimous judgment to the Supreme Court, and the Supreme Court is saying that, look, you guys, you don't have any case, that the Labour Party and the People's Democratic Party. So what they did now was that they just consolidated everything. When it came to the time of the Labour Party, and they were able to say, it's still the same thing that we read to you on the case of Atiku Abubakar, and they were able to adopt it and use the Latin word I can easily remember here. So what we're looking at here is a situation whereby, it was done and dusted at the Court of Appeal.
So let us talk about the 25% FCT status, saying FCT enjoys special status. This was clarified initially by the PEPC. But then still, those who support the other candidates believe that, no, there is something special about the FCT. I saw one of our judiciary correspondents throwing the same question to the Minister of the FCT in some week, who said he was not even there because of the APC. He was only been there as just to see what is going on. I mean, what the Supreme Court will I
didn't expect any other thing from the Supreme Court. Right. It would have been disastrous when you confer a special status on the FCT. It's just like if you win election and in the United States of America, there's this, like you can't say you want to win California. That's right. And when you win California and what the vote you get for California is going to be different from Wisconsin. And if you confer a special status on the FCT, it becomes a big problem. So candidates will now be looking forward to work extra hard on the FCT that, look, this Federal Capital Territory is having a special status and they have to work hard to make sure to win FCT and everything before becoming the president. What they did, the Supreme Court went ahead to read the number of states that was won by Bola Tinubu.
That's right.
That, look, this is just saying 24 states across the country. So the FCT does not have or enjoy any special status. So that's what the Supreme Court was able to affirm, because it would have been twisted if at the end of the day, Supreme Court did not concur with what the Court of Appeals said earlier, that what we're looking at here is that the Supreme Court will be having, the FCT will be having a special status. Yeah. So what we have here is that, look, any other voting bloc, you win FCT, is part of the requirement. It's part of the 24 states that is required for you to win. It's not something special. People will not jostle to win FCT as a state alone. So that have led to a situation whereby, in isolation, other parties will be jostling to see what they can get from FCT because it is a constitutional requirement. Now what they have told us that FCT enjoys the same status as legal states as any other states. Just try to meet 24% of 1/3, I mean 2/3 of the states out of 36%, which is 24%. That is what the Supreme Court has just affirmed here, which is logical and commonsensical.
That actually puts paid to the, the interpretation of Section 299. Of
yes, a lot of people felt that because they said and they felt that yes, that's and confers a special status on the FCT. No.
Absolutely. So let's look at that of the Labour Party. The Supreme Court also adopted the position held by the appeal, held in the appeal filed by the PDP in the appeal filed by the Labour Party. So, also dismissed the same. We had much more noise, coming from the obedience camp, saying that this had been a stolen mandate. And then the last hope, which they believe they had, as rightfully had as Nigerians, is to go to the Supreme Court. But the Supreme Court actually did not waste much time on this particular issue. What's your own reading of this judgment?
Subsequent election is going to, what happened during the 2023 election is going to be like a reference point for any election we're going to have in the country now. Now, any candidate, any political party will now discover that it's a big factor, the resurgency of youths. When you look at our demography, the youths came together, I won't say 100%, they came together and they spoke with one voice. Although they had youths in other political parties, but they came together, they didn't get it. They didn't get it by, just a political party. But Peter Obi was able to do his homework last minute. And let me tell you, look at the figures that everybody got. Peter Obi was able to make a mark in the election. He wasn't strong enough. He wasn't strong enough to get, to bridge that tape. But when you look at the statistics, when you see over 6 million votes for somebody that came from behind, that came from Itato, an obscure party, like the Labour Party, he was able to make his mark. So subsequently, the ruling party will know that they have to work on demography.
Absolutely. Yeah. Sorry, hold your thoughts. I have to get to the Supreme Court, where our judiciary correspondent, Celestina Ira, is standing by. She's been monitoring. Celestina, you've been monitoring this, from daybreak, and, you've been in the court. We saw you live on TV, and we saw you also interviewed some of the APC top brass. Talk to us about how the whole thing went, starting from the mood, and how the judgment was delivered, and when it was delivered, exactly what has transpired so far. Celestina, let me confirm if you can hear me.
I can barely hear you, but the Supreme Court has dismissed the appeal filed by the Labour Party and the People's Democratic Party. the Supreme Court said that the appeals lacked in merits and ought to be dismissed, and they were accordingly dismissed. The Supreme Court also affirmed all the positions held by the Presidential Election Petitions Court, which was the Court of Appeal that started this particular petition by the Labour Party and the PDP, and also that of the APM. The court agreed with some of the positions and all the positions held by the lower court, which is the Court of Appeal, in dismissing the appeal one concerning the status of the FCT, where the PDP and the Labour Party had alleged that the FCT is a deciding state. The Supreme Court said, no, that is not the position. The FCT is not a deciding factor when it comes to the election, and also the fact that the INEC did not transmit result read time on the IRF did not stop the collation and never affected the election, and the fact that the PDP had alleged that they should be returned as the winner of the election, that the result pronounced by INEC was not true. The PDP never brought out any figure as to the votes deducted from their vote or the number of votes they ought to have scored if the result were transmitted time, and also that we recall that the Court of Appeal struck out some witness statements by witnesses of the PDP and also that of the Labour Party. We recall that these witness statements were obtained after the 21 days, which is allowed by law for the petition to be filed. And the court has said that the trial court, which was the Court of Appeal, said that you cannot bring in fresh witness statement when you did not file it when you were filing your petition. The list of witnesses were not presented at that very stage. So that was why the court expunged those witness statements. The Supreme Court also agreed and said, yes, a subpoena is not a way to circumvent the law. Because the court itself granted a subpoena for you to subpoena these witnesses does not mean the court will admit their witness statement. So the courts agreed with the lower court in also dismissing that particular position. I will also recall that the trial court said that the issue of suppression of vote can only be attested to by the polling unit agent. The PDP only called the state collation agent and the national collation agent. The polling unit agent, they did not call the polling agent. The alleged suppression of votes, these the Supreme Court said were hearsay evidences. So basically the Supreme Court affirmed what's the issue of double nomination, which the Labour Party had alleged that the Vice President had double nomination. But the Supreme Court said that we have already decided on that position in the case between the PDP versus Kashim Shettima, wherein the court said that there was no case of double nomination. And on that basis, that was what the Supreme Court also used, we recall, on the 23rd of October, used in dismissing the APM's petition. Also, the burning issue that gained traction was the fact that the PDP tried to present new evidence. They had sought the court to admit in evidence the certificate of the president from Chicago State University, which they said in their affidavits that they could not present at the Court of Appeal because of the time at which they obtained it. They had prayed the court to invoke their Section 22 of the Supreme Court Act in 2004, and the court said that they cannot do that because the 180 days given to the Court of Appeal to decide on the petition had elapsed, and they did not file that particular evidence within the 21 days from when the election results were declared. So they said they cannot do what the Court of Appeal failed to do. And to grant appropriate value, we also recall that at the hearing, which was what happened on the 23rd of this month, the Supreme Court raised issues as to how the deposition was conducted. Yes, they got a certificate from the school. They raised issues. Did the school come out to discredit the certificate? No, the deposition that they carried out with the registrar of the school, where was it conducted? So these were the issues, and the court has today said that there must be an end to litigation. As far as the presidential election was concerned, 2023 is concerned, every issue has been laid to rest, and President Bola Ahmed Tinubu's victory has been affirmed.
All right, Celestina, you need to hold on a bit because I'll still definitely be asking you about what difference were you able to make from the fact that you monitor the PEPC as well as the Supreme Court. I'll definitely come back to you on that, but I need to come to the studio to Ayodele Ozubakun, who has been having this conversation with me. In comparison to what we saw, what transpired with, from the PEPC and then the Supreme Court, that lasted the earlier one lasted about 13 hours or thereabouts, and this is just barely 4 hours, so to speak. What difference what striking difference do you make of this?
I told you earlier that the Court of Appeal had done the job. They did everything. The Court of Appeal did everything. It was just meant for the Supreme Court to look at the logic behind the reason and the logic behind the judgments. And the Supreme Court, looking at the rules, that Mr. Atiku can bring a fresh plea. And looking at what was done by the Court of Appeal, it was just adopted holistically. The Court of Appeal did 80% of the job. The Supreme Court what it just did today was just to affirm what the Supreme Court. And that's why the Senator told us earlier that the Supreme Court said, look, if you fail to bring this fresh evidence in during the time we gave you as the time schedule, in terms of technicality and the time that is permitted, if you've not been able to bring it in, now you cannot bring it in. That we cannot do what the Court of Appeal did not do. So I will advise Mr. Atiku Abubakar and Mr. Gregory Obi to just put that call to Bola Tinubu as the President of the Federal Republic of Nigeria right now, that the Supreme Court has affirmed it, and we should come together, and Nigeria is one. Governance should be put on the top border now. They should just call Bola Tinubu and congratulate him. Every other thing is now left for 2027 election. Governance should start. We have a cabinet, we have ministers, we have everything in place. Our economy is in shambles. A lot of things, it's not going right for the country right now. They all must come together and make sure we get Nigeria to become a great country again. So, in terms of legalese, this is the end. It's the apex courts. There's nowhere to go to again. And, some funny people in time past, they'll go to the Supreme Court and write to them again, like what we had in 2007, that, look, interprets what you mean by
they should review themselves.
You review themselves and interpret themselves. I hope that will not happen. And I hope some lawyers will not be sanctioned or derobed by encouraging any of their clients to pull any other stunts after this. This is the apex courts, and everything they've done here will become what the lawyers call locus classicus. That's a reference point in future. So the judgment of 2023 presidential election becomes a locus classicus for any presidential election in future.
Well, prior to the 2023 general election and then post-2023 general election, the noise, the accusations, the allegations and all of that, here and there, saying that it was the worst election. But we had experts, home and abroad, who said this was one of the best elections that Nigeria has ever done. With the fact that the one who emerged the president of Nigeria, the incumbent president, also lost his base. So do you think this will put paid to some of the noise coming from opposition parties, saying that they do not believe in the integrity of this election and also the credibility of the Independent National Electoral Commission?
As a journalist who've been covering this process for a long time, one takeaway thing there is that, look, emotions, it doesn't have anything to do with your emotion. It's 100% about the evidence, things you bring to the table, what we've been having, what you are making reference to, what you've been seeing, the pressure you've been seeing on social media, all eyes on judiciary, everything you've been reading has no place in law. Law deals with hard facts. So whatever the emotions, as at that time, a lot of people feel that, it was a keenly contested election. And if you see the president who won with just below 40% of the entire vote cast, so it was divided. But when you now see it, Peter Obi had 6.1 million, and Atiku had 6.8 or 6.9 million. When you see that statistic, the president was a clear lead of 8 million votes. And a lot of people feel that, with INEC promising the upload of IRF real time, that did substantial damage to the process. But as according to the Court of Appeal, the Court of Appeal has said, you have refused to prove beyond reasonable doubt that if IRF wasn't working, if INEC is saying there was a glitch, and if you still had your form EC8A, that you all still submitted across 170-something thousand polling units,
and
across
then
the 774 local governments.
have copies
yes,
of
the police will we have, all the agents, they will sign, all the polling units. It's as if a day like this, I knew that a day like this might come. So there's a process. That process ends at the polling units. All political parties' agents are required to sign that from EC8A. At the end of the day, the police will sign. So when you get to the ward, it becomes EC9, and the process goes on and on and on like that. So that the inability to upload real time on IRF does not substantially negate the process. That's what the Supreme Court is saying now, that, oh, Nigerians, yes, it raised your hope. Justice Okoro acknowledged that. Right. Yes, it raised your hope. Oh, it dashed your hope. Hope INEC will be able to listen to this now and say, you don't need to raise our hope subsequently, you don't need to dash the hope. And that encouraged a lot of Nigerians to come out to say, I will see it on the IRF. But for you to now come and say, the inability of INEC to upload it on the IRF marred the whole system, you need to prove it. And the People Democratic Party and the Labour Party, they weren't able to prove jack. And that was what brought about the unanimous decision of the Supreme Court.
That's speaking to the fact that one of the justices of the PEPC said that, did you want us to go to the streets to start looking for evidence?
Yeah, yes. Well, some people even felt that. Some people felt that the tone of that judgment in the Presidential Court of Appeal, that was it what? But I was listening to a judgment in the United States 2 weeks ago, and the judge came out and the judge said, look, this man is the Lucifer incarnate, as in the course of judgment. Judges, they have their words they use, and they use the opportunity to remind lawyers of their failures, of what they refuse to do. So that's when one of those judges said, you don't expect us to go on the streets to start looking for evidence for you.
Well, I think Nigeria's election has actually come a long way. Looking at our democratic values, entrenchment of democracy in this country, where we only get to read or listen or watch the outcome of it on television or on radio on the pages of newspapers. But now we all had to be witnesses to what the justices were reading out as judgments, and they made it simple. Well, we'll talk about the legalese, we'll talk about the language later, but how far have we come in terms of witnessing how decisions are made in court?
Now, at the initial level, if you remember, the Court of Appeal did not allow live coverage. Now, the Court of Appeal, looking at the sensitivity, they were going to bring witnesses, and that might compromise the security of those witnesses. People were going to bring some people from abroad, some people came in within, some experts came.
We even heard of one that will be coming from Russia.
Do you understand?
Who has never lost a case,
yeah,
and all of those.
Yeah. So it might be counterproductive at that stage for you to bring in the cameras. What they just did now was just for our judgments, for the judgments. And the reason behind our judgment, that was when that judgment last said, went on and on and on. They didn't allow for the process for cameras to come in. So in future, I don't think anything will change. But the innovation here, the confidence here is that when we are giving the verdicts, and we didn't see the face of any of those judges while reading, we just saw the cutaways and everything of the courtroom and everything. So people will listen and they will be able to assimilate what happened. So the most important thing here is the logic behind how the Court of Appeal arrived. I told you earlier that the Court of Appeal did a very, very serious job. What the Supreme Court just came here to do today is to affirm what the Court of Appeal would have done. And if you see from 1999 before now, you have seen that, look, over and over again, they've never had a situation that the judgment has been unanimous. 7 justices of the Supreme Court saying, yes, we agree with this judgment. It's monumental. I think it's a congratulations to the All Progressive Congress. And I told you earlier that the candidates, just Atiku and Peter Gregory, we should just put up that call to congratulate Tinubu.
And above all, it's a congratulations to Nigerians, because we are all able to witness, the outcome of this judgment, all of these prosecutions and allegations here and there. Well, we'll take a break from this point, and then this is where I sign out On the top of the hour, my colleague Precious Amayo will be here with the latest updates and more analysis on what we've seen so far from the Supreme Court of Nigeria. Bye for now.
I'm here to rule forever, and nothing can stop me.
That woman is wicked.
I love you all. Get lost, wretched, poor thing.
She must be bipolar.
The money, power, respect I have, I did it by doing everything.
That low-budget Beyonce.
Africa's creative market is here again. Yes, the biggest gathering of is back. First in Lagos, November 2023, and in Dubai, March 2024. Come join thousands of creative professionals as they gather with their counterparts for trainings, workshops, masterclasses, conferences, fashion shows, networking, and a mega music concert featuring some of Nigeria's biggest acts and many more from Thursday, November 2nd to Wednesday, November 8th, 2023. The Dubai event runs from March 5th to March 9th, 2024. Register to be a delegate and get the full event schedule on www.africacreativemarketglobal.com. Call the ACM team on 080-611-80294 to book an exhibition booth, and call 0703-623-0247 or 0809-367-7272 for sponsorship and advert bookings. Be there.
Voted as the best TV station of the year. TVC News breaks into the core of every event as they happen. Following all nationwide big and impactful stories. Without the news from every perspective. Covering every human angle. I am Veronica, bringing you the news you would want to watch.
At TVC News, wherever the big news story is happening, we're geared up to break it. TVC News, first with breaking news.
Genuine business people desirous of success in today's environment ignore the taxman only at their own peril.
The idea we have is, can we not use NIN, that's the National Identification Number, as a unique and primary identifier for individuals? For businesses and incorporated entities, we use CAC registration numbers. Once you do that, you tie those numbers to all economic activities, getting a job, going to university, registering a vehicle, registering land, opening a bank account, getting a mobile phone, payment cards, importation of anything, buying PTA, every economic activity to be linked to that data to help us to make sure that people pay the right amount of tax.
For up-to-date and accurate information on your obligations, duties and rights under the various tax laws in Nigeria, watch Tax Matters on TVC News Thursday, 6:30 p.m. to 7 p.m.
Welcome to the transformative journey of Gombe State. Like a beautiful bride in the savannah, Gombe State is steadily growing to become a commercial and investment hub with accelerated development of world-class infrastructure, quality education, and healthcare. The jewel in the savannah, under the visionary leadership of Governor Inuwa Yahaya, is taking giant strides in the quest to making Gombe State a paradise in Nigeria's northeast region. Join us on this adventure every Thursday by 3:30 p.m. as we explore Gombe's transformative journey to greatness. Kano State, the commercial capital of northern Nigeria, is on the march to progress and innovation with Governor Abba Kabir Yusuf in the saddle. Be part of the vision that is transforming Kano State into a hub for economic growth and opportunities. Hear directly from the governor as he engages the people, listens to their concerns and shares his vision for a brighter future. Explore the developmental projects embarked upon by his administration to change lives, from infrastructure, healthcare, education to tourism. Watch the rich history of the culture and tradition of Kano and savor the vibrant spirit that unites the center of commerce on Kano Spotlight. Thursdays at 9:30 p.m. only on TVC News.
It is time for consolidation of recovery efforts in Borno State, devastated by years of insurgency and terror. From security to education, health, agriculture, infrastructure and housing, every sector.
Hello and welcome to TVC News at 1. Our top stories this hour. Supreme Court upholds victory of President Bola Tinubu, dismisses PDP Labour Party's appeals. Litigations are over. It's time for governance. That's from the Chief of Staff to the President as APC supporters jubilate after court verdict. Now to Nigeria, Israeli airstrike on houses in Han Yunis kills 30 persons. Several others fear trapped under the rubble. In sports, Manchester City continue their defense of the Champions League trophy as they beat Young Boys 3-1. We're bringing you live coverage of the Supreme Court judgment, which has been delivered by a panel of 7 justices, headed by Justice Inyang Okoro. The Supreme Court dismissed the appeal filed by the People's Democratic Party, challenging the victory of President Bola Tinubu. In a unanimous judgment, a 7-member panel led by Justice Inyang Okoro dismissed the appeal for lacking in merit. The panel of justices also dismissed the appeal filed by Labour Party for lacking in merit. While reacting to the verdict, the Chief of Staff to the President, Femi Gbajabiamila, says, now that litigations are over, it's time to focus on governance. Now, it's jubilations at the Eagle Square and some parts of Abuja as APC supporters and some residents celebrate the verdict of the Supreme Court. Let's now bring in our correspondent, Moyo Thomas, who joins us live from the Eagle Square for more updates. Moyo, we understand that it is celebrations at the Eagle Square. What more can you tell us about this? All right, Moyo, I'm asking you what more you can tell us about the jubilations and celebration. We understand it's ongoing at the Eagle Square.
Come together from different civil society organizations and different youth groups also.
Right, those are pictures from the Eagle Square where jubilation is currently ongoing. We're trying to speak with our correspondent who is there monitoring that situation. But as you can see, these are supporters of the APC and, of course, the president as well, who are now celebrating the Supreme Court judgment for affirming the election of the president. All right, let's bring in Moyo Thomas, our correspondent who is there. Moyo, these are live pictures we're seeing now of those who are celebrating. We can see live band. Talk to us about what exactly, who these people are, and then, what exactly is going on at the moment.
Yes, there's been a jubilation here. Okay, there's been jubilation here since morning, since the court started its proceedings, and since the Supreme Court started its judgment. We saw different groups, different civil society organizations also jubilating, and the youth group too. And I have with me the national youth leader of the APC to talk to us more about why they found it necessary to come out and celebrate today's verdict.
All right, I can see that banner there that says Nigeria say Jagaban on that truck, obviously celebrating the win and the victory of the president at the Supreme Court. We'll get back to Moyo for more on that, but let's bring you some highlights of the judgment delivered by the Supreme Court today. The lead justice Inyang Okoro held that the Supreme Court lacks jurisdiction to admit new evidence, thereby dismissing PDP application to bring in fresh evidence. He also stated that nothing in Section 285, subsection 6 suggests that the Court of Appeal can hear election petitions without time limits. And also in the judgment, Justice Okoro held that no issue for determination by the appellant points on certificate forgery allegations, which was brought before the court. The court also ruled that failure of IREF does not stop the collation of results, and although non-functioning of IRF may have reduced confidence of Nigerians in the electoral system, but the failure to transmit results to IRF did not affect the election. He also noted that FCT has no special status with regards to election. We were staying on this story, and we have still a senior political correspondent, Ayodele Ozubako, still with us in the studio. We saw that jubilation there by supporters of the APC and the president, I believe it was. Was that expected, and did you expect even more than that?
Yes, it's expected that a long-drawn battle that started well ahead of the 2023 election and that culminated to the declaration of Bola Tinubu as the president of the country. And that a lot of people were saying that, look, well, till after they might have gone to the courts, and if whatever the court says, that the president is not sitting pretty till after the court verdicts. So they went to the Court of Appeal, Presidential Court of Appeal, and the Court of Appeal spoke, and a lot of people were still pessimistic, saying, well, till the final court in the land, that's the Supreme Court speaks. And the Supreme Court just spoke today, and jubilation everywhere. And it's done and dusted. So all supporters of the president, Nigerians and people that voted for the president, and even people that did not vote for him, they should just come together and wish the president well. This is done and dusted till 2027 officially.
It does look like, there is some level of stability, as it were, in the country. But I remember when the president won, there were questions as to who called and who did not call in terms of, presidents around the world. Does this sort of put that question of legitimacy to rest now?
Everything that has to do with legitimacy, this has addressed it. This is the only official quarter that is permitted by the law of the land. That if you're aggrieved, if you don't agree with what happened on the 25th of February, proceed to the court. And all the candidates submitted themselves to the jurisdiction of this court. Everybody. So everybody that felt, some did not actually come to the court. They just felt that, well, we'll wait. So all the major players, that's the Labour Party and the People's Democratic Party, submitted to the jurisdiction of this court, and they went to the Court of Appeal, and not tired, not satisfied with the verdict of the Court of Appeal, proceeded to the Supreme Court. Thank God, because of the Electoral Act evolving. Before, we used to have a situation whereby this might span till 2 years after election, but now it's 180 days. After the election, you are given 27 days to file your petition. After that 27 days, you are meant to start. The tribunal will have 180 days to adjudicate on the whole thing, make your submission within...
I have to put you on hold for just a minute, but we want to take that reaction earlier, because you didn't mention it, that you mentioned it earlier about all of this coming to an end. And while also reacting to that verdict, the Chief of Staff to the President, Femi Gbajabiamila, also said the same thing. He said, now that litigations are over, it is time to focus on governance. We just want to take that reaction from him.
That the decisions were unanimous, without any dissenting voice. Like the judge said, all litigation must come to an end. They addressed all the issues, about 7 of them. And those issues were, and the judgments on each of the issues were clearly unassailable as far as I'm concerned. That's come to an end now. We now have to all come together as one country, one people, and move ahead and take this country where it rightfully should be.
I came here as somebody who's interested, as somebody who wanted the country to move forward. So I congratulate Mr. President, and I think that this has come to the end. No more speculation. That's why Mr. President can focus and do what he's supposed to do for Nigerians.
Pertaining to acceptance of this verdict, I urge our colleagues, politicians, to accept it in good faith. And also I have to use the opportunity to congratulate politicians, to congratulate the leaders of the opposition political parties, because it is better for them to resort to judiciary, which they have done so.
This is not just a victory for our party APC. It's a victory for the country. And we want to salute the judiciary, starting from the Supreme Court, the Appeal Court. Their judgment was very detailed, was very meticulous. We laid the foundation for the Supreme Court judgment. I want to salute the judges of the Supreme Court as well. They were straight to the point. And I believe that this judgment would be seen worldwide as that which is in line with global best practices in law.
Governor of Ogun State, Akpo Abiodun, speaking there earlier. We saw also got reaction from the Chief of Staff to the President, Femi Gbajabiamila, the National Chairman of the APC, Ganduje, and the Minister of the FCT, Nyesom Wike. But let's now get into how what this judgment means for the APC, as we bring in the National Publicity Secretary of the APC, Felix Moka, who joins me virtually on the news. Good to have you join us.
Much. Pardon me.
Right, so let's get how your party is reacting to this particular judgment. Like, were you surprised by this judgment?
No, thank you very much. First of all, let me congratulate the President of the Federal Republic of Nigeria, Bola Ahmed Tinubu, on this landmark decision by the Supreme Court of our country. No, we were not surprised by this outcome. We have been very clear, and we were confident from the get-go. This was the judgment we expected, because the facts that the petitioners took to court had no way out. There was no basis, quite frankly, for all of the arguments that were made before the courts. So the petitions court, the first court of appeal, ruled on this matter, and was just affirmed by the Supreme Court. So there's nothing about it that's surprising. We were very confident that this would be the outcome, because the facts would only lend itself to this very outcome.
Some have said because of this judgment or as a result of this judgment, the question around legitimacy is now laid to rest. Are you also heaving a sigh of relief, in that regard? Was this a question of legitimacy for you or just affirmation?
Look, it was never about legitimacy because the institution that's charged by law with the duty to conduct elections conducted the elections, and that's INEC. They observed all the protocols laid down by law and, counted the votes and declared the results in favor of Mr. President. So the question of legitimacy was never an issue for us. Those who tried to do so, to raise that question, did so for their own very narrow, selfish, political, purpose. So for us, this is really, look, Nigeria is a constitutional order. We are a democracy where three arms of government function, doing their jobs assigned by the Constitution. The courts were given the duty to adjudicate between disputes, in disputes between citizens or between citizens and the government. So when these cases were filed in court by the Labour Party and the People's Democratic Party, we knew that a day will come, a day like this will come, when that institution of our courts will have the final say in the matter. And today, they rested this matter. The judgment was very eloquent, it was completely definitive, and it was final. And I hope that our friends in the opposition will take this as the end of this matter and, reach out and, work with the government to begin to focus on what is important, which is the task of, getting governance going in the right direction.
And the president has now reacted to this particular judgment. The president said, with this victory, it's time for more work. He also said that everyone must now come together and work for the good of Nigeria, that this is about the future of the country. And so we're just going to give you that reaction coming from the president.
I've started from day one to work hard, regardless of the court cases, okay, and just strengthen my resolve to do more. A challenge of this nature and a future of this nature is more work and more hard work, more dedication. Just appeal to the sense of patriotism of Nigeria to have a change of mindset. Let us be positive about our country. Be ready to contribute in all ways possible. There's no promise of El Dorado from day one. We're all in this boat of diversity. A member of the same family, living in the same house, but stay in different rooms. And it is important that we recognize that we have no other country but this one. So we better be committed to it, not for the sake of our own self-aggrandizement, our commitment to the values, the creed of dedication, patriotism, and commitment to the value of this country.
All right, that was the President, President Bola Ahmed Tinubu, reacting to the Supreme Court judgment. We still have Felix Moka, who is the APC Publicity Secretary, with us. I want to get your reaction to that statement from the President.
We have no country but this one, so says the President, and I agree. This is a moment, this decision today is a clarion call to everyone, every Nigerian, irrespective of your political persuasion or political party affiliation, or for that matter of your gender or origins or religion. It's a solemn call to Nigerians, to all of us, to stand up for our country, to stand up shoulder to shoulder, to tackle those challenges that confront us as a people. This is the time. There's no better time for everyone, both those who went to the court and those who lost and those who won, to come together to begin to put Nigeria first and to put the people of Nigeria first and to, fight and battle for their interests rather than for these partisan interests. That should be rested. So, I agree with Mr. President that we need now to focus on the well-being of the least amongst us. Those of us who cannot even help themselves. It is for them that government exists. And I think that this is the day that should mark, a turning point in the way we engage, in the language we speak, in the way we critique. Yes, we can critique and affirm. We can disagree with government. We can offer constructive criticism. And I really will invite the opposition in this country at this time to now step into that role as the political opposition, to work with government, point out where there are gaps, where there are ideas for improvement, and to offer those ideas so that this president can continue to do the very best that he's able to do with his tenure for all of us as citizens of Nigeria.
All right, so Mr. Felix Moka, I will just put you on hold today. It's your party that won, so we have a lot of questions to ask you. Respondent Moyo Thomas is at the Eagle Square, where supporters of the APC and the president are jubilated. Moyo, what more can you tell us at this moment?
Okay, so we're actually at the 3 Arms Zone, not just the Eagle Square. This is the 3 Arms Zone that leads to the National Assembly and the Supreme Court side. And we have earlier on had different civil society organizations and youth youth group celebrating the verdict of the Supreme Court. A lot of them were very happy, jubilating, dancing, and a lot of other activities were also ongoing as the verdict was being delivered by the justices. And I have the leader of the APC National Youth Leader with me to tell us more why they came out to celebrate this day.
Thank you very much, Mr. Thomas, and thank you, TVC. First, I want to say congratulations to Nigerians on this victory. Victory for young people, victory for women who already dominate the cabinet of Atiku Bola Ahmed Tinubu, victory for the young people who already have a seat at the table as SAs, as SSAs, and even as ministers. We have 2 in the cabinet who are young people, of course, and the other young people like the Minister of Humanitarian, who's also a young person. So it's a victory for all of us, a victory for Nigerians. And we celebrate Atiku Bola Ahmed Tinubu's victory today. And we know that on his mandate are we standing. We thank God for this victory. It's what we've been expecting. Now the president can focus on delivering for Nigerians, on transforming our economy, on improving our foreign relation, on also investing in our education and creating more opportunities for the future of our young people. And so that is what this victory today at the Supreme Court means. Enough of all the shenanigans and all the distractions for our president. The administration will now focus on building a Nigeria that is fit for children and young people.
Thank you very much, our youth leader. That's a youth leader there, Mr. Dayo Israel. And just as he said, and as the president also said earlier, this verdict also just reinforces the need to face governance, which is the next thing for Nigeria. Thank you, Precious.
Thank you, Moyo, for capturing that moment for us. My correspondent there at the 3 Arms Zone, Moyo Thomas, who just spoke with the national APC youth leader, Dayo Israel. But let's take a break. When we return, we'll speak with still the publicity secretary of the APC. Stay with us.
Your Pearl and Beauty deodorant with natural pearl extracts and avocado oils for soft, smooth, and beautiful underarms. The perfect balance of 48-hour protection and care with delicate fragrances. Feel the power of pearls. Nivea Pearl and Beauty for soft, smooth, and beautiful underarms. Try our new Pearl and Beauty Black Pearl for smooth and perfumed underarms.
Looking fresh for your date? Get even fresher with Close Up. New Close Up Triple Fresh formula. It cleans deeply, fights 99% of bacteria, and cools intensely, keeping you protected and fresh.
Protected and fresh. Protected and fresh.
Let's take a picture.
Protected and fresh.
Still fresh, still protected.
Feeling cool and protected.
All day confidence to get close.
Oh yeah, take the Close Up shot so close.
New Close Up Triple Fresh formula. TerraQ. Unwrap joy. Unleash taste.
Thanks for staying with us on TVC News at 1 as we stay with a live coverage of the Supreme Court judgment, which was delivered earlier by a panel of 7 justices and led by Justice Inyang Okoro. We're also now staying on reactions to that judgment. Earlier, we saw reaction from members of the APC, members of the President's cabinet, and the President himself has also reacted to that judgment. We've been speaking with the National APC Publicity Secretary, Felix Moka, and he's with us still. Mr. Moka, just before that break and before we went to Muyo Thomas, you were making a clarion call to the opposition, saying that, look, it's time for them to now begin to constructively criticize the President on his policies and also share
the President of the Federal Republic offered his hand, in fellowship to his opponents, those who contested against him, especially Atiku and Peter Obi. He did offer his hand to them, to invite them to join him to tackle the challenges of governance in our country. And he still reiterated that position in his reaction to this judgment. And those of us in the party, we are very clear about this, that, this country belongs to all of us. We had an election, the individuals who were involved who felt that they had grievances, approached the courts. The courts, the Court of Appeal sitting at first instance, and the Supreme Court have now decided. So look, I think at this stage, those who were involved and their supporters need to understand that, the country is bigger than any one person, bigger than the President, bigger than Atiku Abubakar, bigger than Peter Obi, because it involves all of us, us 200 million people. So our collective destiny is at stake here. So my hope is that, this judgment will, I think, be an incentive for those who still felt aggrieved or who feel aggrieved to, rest their grievances and look forward to the next, round of election in 2027. But for 2023, I think this is done. So, our hope is that we will continue to reach out and to appeal that, people in the opposition, their leaders and their supporters will put the country first over and above their individual partisan political interests.
We know that this cabinet, the President's cabinet, has pretty much taken shape. Some would say, look, there is still room to bring in 1 or 2 persons. And if the President were to extend a hand by appointment to the PDP and the Labour Party, how will the APC National Executive Council or Committee react?
Look, the President has, complete prerogative to appoint any individual or individuals that he believes bring, I think, to the business of governance some value and some good to help solve some of our national questions. So whether he brings them from the APC or from the opposition parties or from the professional sector or from anywhere, as long as they're Nigerians and they have the competencies to add value, I think the President will make that call. He's made that call already. When you see the likes of former governor of Rivers State, Nyesom Wike, as Minister of the FCT, who obviously has a different political background. He's brought people like that into the government because he believes in their capacity to help the government to implement the renewed hope agenda. So we as a party, we stand firmly behind the President, and we will provide that support that he needs to govern this country, to the utmost benefit of all of us.
While it looks like the APC has the biggest victory in this whole process, because the Supreme Court has now affirmed the election of the president, but when you pay a keen attention to the opposition, it does seem like an alliance seems to have been created between those political parties. Is your party concerned about that, especially as we now head towards politicking for the 2027 at the background anyway, maybe not at the forefront?
No, we're not concerned of an alliance between strange bedfellows. I mean, quite frankly, I don't see, even though Peter Obi was Atiku's vice presidential candidate in 2019, I don't see anything now that brings them together, quite frankly, other than just a headline opposition to the president and APC. But, in the actual sense of it, I think that APC is not perturbed by because we intend, and the president has made clear that he intends to offer good and effective governance to Nigerians. And I think Nigerians are the voters, they're the electorate, they're the ones who ultimately will decide in 2027 and beyond 2027 who they choose to give the mantle of leadership to. And I think that for us, being in office today with the president, we have an opportunity to continue to deepen our commitment and to serve Nigerians the way they deserve to be served. And I think that as long as we discharge that burden of really doing the very best we can for Nigeria, we're confident in 2027 and beyond 2027, the Nigerian electorate will again entrust this job to our party, the All Progressives Congress.
And let's talk about one of the biggest judgments, as it were, some people will say today, which is that of the certificate controversy. A lot of people were watching to see how that would play out, and that the Supreme Court said, look, they cannot sit over that judgment. It should have been decided at the appeal court. What does that mean for your party? What's the implication of this?
And from the get-go, with all my public representation and on this matter and discussions, I've been very consistent. I'm saying, look, you do not and you cannot at this stage in the process, introduce fresh evidence. And by the way, the Supreme Court was also very clear on this point, that this is not a judgment of a foreign court. This is not testimony that was taken before a judge in the United States. This was a discovery, a preliminary discovery that was looking to settle the production of documents. So the registrar who testified in that process, in a law firm, at a law firm, not before a judge. There's a reason that witnesses come before a judge, because the judge has to be able to observe their demeanor, make an assessment whether they have believable witnesses or not. There's a lot of legal, issues that the judge has to figure out when a witness is presenting testimony and getting cross-examined. But this registrar in that process in Chicago was engaged at a preliminary level. And so, when you suggest that someone forged a certificate, which the president did not, of which he was a graduate of Chicago State University, you must, come with some seriousness. That's a criminal allegation. So you must prove it to the criminal standard of proof, which is beyond reasonable doubt. And you don't then take a testimony before at a law firm and then elevate it to that level, that pedestal that they tried to do, which the Supreme Court said, look, this is a joke. This is even a bad joke. It's beyond a joke. You don't bring such a document to the court and expect the court to just take it in and at an appellate level. The Supreme Court is the apex court of our land. It's an appeal court. It's not a court of trial. It's not a court of first instance. It's not a court where you review evidence. And the court was clear. All of the period, the time that the petitioners had to bring their evidence before the court had long expired. And when that time expires, the courts no longer have jurisdiction to deal with this matter. The Court of Appeal had lost jurisdiction. Therefore, the Supreme Court cannot assume jurisdiction over a matter for trial that the Appeal Court didn't have anymore. So look, all in all, I think that the decision today was fantastic. It was eloquent, it was short, but it was straight to the point. And I think that every lawyer in this country, whether you're on the side of the opposition or on the side of the president will agree that this decision is impeccable. It's absolutely unassailable, as the court said.
And I just want to take that one statement from the Supreme Court on that certificate controversy, where he said, no issue for determination by the appellant points on certificate forgery. How would you react to that particular statement?
No, what the court was saying was that the motion that was brought to urging the Supreme Court to admit that evidence had no basis to stand, because it was not pleaded, it was not a ground of appeal, and was not, had no relevance in the entire appeal system. So you don't come at this level to try to bring a fact that is, heavily contested, that is terribly contested by the respondents. You don't bring it at this stage because there's no space, there's no opportunity for trying that. Because to try that, you have to actually almost constitute a trial within a trial at the Supreme Court. And that's not, the Electoral Act is very clear. These electoral matters are sui generis. They stand on their own, and they are, of their own, nature. So you can't simply just bring an evidence at this stage and expect the Supreme Court to begin to call witnesses and examine witnesses and then make a decision. If you do that, one, you violate the constitutional prescription of time limits for hearing these cases. Second, this case will then be, infinite. You will litigate it for the next, 10 years, possibly, and there'll be no end. And nobody wants that. We want clarity, we want certainty, we want an end to this process. And today marked the end of this litigation, and we are very pleased with the outcome.
All right, let me also put you on hold as I bring in our senior political correspondent, AY, back into the conversation. AY, I want to stay on the certificate controversy because we saw a lot of press conferences, a lot of media razzmatazz, if I would use that word, around from the opposition parties around that certificate controversy. And then the court says, look, no issue for determination by the appellant points on certificate forgery. What does that tell you?
They didn't plea for it. For their plea at the Court of Appeal, it wasn't part of what they requested for. And the court just proved today that the court is not expected to be a place where you have a Father Christmas seated somewhere to do any gifts you didn't plea for. It wasn't part of the whole thing. If they had done their homework well before that Court of Appeal, before they would have filed it in the Court of Appeal, and it would have been trashed out. Maybe it's a pre-election matter, maybe it's post-election matter. It would have been trashed out at the Court of Appeal level, and the Supreme Court is saying that what this Court of Appeal did not touch, we cannot touch it. It's a no. There's a time frame. You don't expect us to go into what you didn't pray for. That it's not like that. It's against the rule. So the Supreme Court said it unequivocally today that no, Mr. Atiku felt that he had something like a scoop in journalism, we call it a scoop, something big to rely on. And that was his final thing to bring on to. Actually, if the Supreme Court had allowed it or admitted it, it might have been counterproductive. But the Supreme Court is saying that you foray to the United States of America, everything there, according to Wole Olanipekun, the objectivity behind that move and everything, it was questioned by the lawyer of Bola Tinubu, and they are saying that for the rule of this game, you've gone against the rule of this game, that you didn't plea for it, and so you will not get it.
And as you followed that proceedings today, what stood out for you, and what was your key takeaway?
The Supreme Court, they weren't ready to waste our time. They felt that the Court of Appeal had done everything. For me, the Court of Appeal lead the foundation. They've done 85% of the work. The Supreme Court is just saying, look, let me check what the lower court has done. Is it in line? Is it in line? Is it in line? They cross-checked everything. And from cross-examining it, I expected out of the 7 judges, I expected a dissenting view. Do you understand that, look, because there was a time people were even, members of the public were even questioning the language of the Court of Appeal. The Supreme Court actually addressed that. They saw nothing wrong with the language deployed. So after putting the spotlight into what the Court of Appeal actually adjudicated, the Supreme Court said, look, we all concur, 7 of them, 7, all concurred. So it's home and dry, done and dusted, Precious.
So I wanted to, because a lot of people say, look, and that's the truth, it's within their constitutional right to go to court. Whoever wins or whoever loses election, you have the right to go to court. But sometimes, we see the media frenzy around it. We see supporters of both parties, and loggerheads, whether on social media or in person. It's just through that process. What does that mean for us, as a nation? What's the impact of that on us as a nation?
We have to heal. After this exercise, President Bola Tinubu, we had to, the confidence that Nigerians are actually giving to him. We have to work, and this country must work, and we must come together as a nation. That election actually divided us, so we must reach out to all our sundry. And the gladiators must come together and work with President Bola Tinubu to build a nation. We have a nation to build. After that election, we're badly fractured, which is a normal cycle after any years, the 4 years of election and everything. So, and the National Assembly, we have to work on our electoral process. We have to work on it and to see how they continue to perfect it. It's an ongoing work, but above all, we have to heal as a nation and move forward. That's the only thing. Because the sentiment expressed on the social media, the Supreme Court actually said it today, like the issue of the IREV, that yes, Nigerians were concerned and that truly they are meant to be concerned about this thing. So we have to go back to the drawing board and see how we deploy our technology. INEC.
I was just going to ask you that this doesn't mean that INEC should become complacent in that regard. But if anything were to go on in 2027, this does give INEC some level of credibility to say, look, there is already a set ruling in this regard that with or without the IRF, it doesn't mean that election results are not credible.
Except the National Assembly fine-tune the law to accommodate the IRF when it becomes a legal issue. But most Nigerians, they did not see that loophole there. It was just an added incentive promised by the Independent National Electoral Commission. It wasn't written in black and white. That's what the Supreme Court has just proved today, that it did not substantially alter the process. So that incentive, maybe INEC will need to go further. That's all. Maybe in 2027, it will no longer be a kind of incentive. It's going to be a legal thing. That is when we can hold INEC accountable that, it's part of the law, that you have to upload this in real time. Failure to do it, that will bring a question mark on the election. But for now, the Supreme Court has spoken.
Let me also get Felix Moka's reaction to that judgment on the IRF, where the judges say that, look, although non-functioning of the IRF may have reduced confidence of Nigerians in the electoral system, but the failure to transmit results to IRF did not affect the election. Mr. Moka, how do you react to that?
No, that was exactly as stated by the tribunal that the Supreme Court just reiterated. And I agree completely. Because the Electoral Act is very clear in the authority that it gives to INEC to determine how election results are collated. And, look, as even the petitioners recognized, these were part of INEC's own provisioning, their guidelines, in their zeal to make, the process more transparent to Nigerians, to give Nigerians a window. I mean, just like today, for example, this judgment was televised nationally. It was on live television. But that is not the norm. The Supreme Court, in its own discretion, decided to allow cameras and TV stations and the media to televise the judgment nationally today. But tomorrow, when the Supreme Court is sitting on a different matter, I don't think the TVC or AIT or Arise News will simply just carry cameras and walk into the courtroom. Because that's not the norm. The court decided today to do so. So you cannot now, tomorrow, file an action in court to say that the Supreme Court disallowed cameras in the courtroom tomorrow because they did, allow it today. That's exactly what INEC did. INEC decided on their own to give Nigerians more access to information during the elections to be able to view some of these results simultaneously as they were being uploaded. But that then did not become, by any legal or even common sense standards, that the results uploaded to IREV would then become the basis for collation. The law prescribed how results were to be collated. So look, I think that the courts, this like the court said, these are elementary issues, really. That any objective lawyer or reader of the Electoral Act will see that there was no basis to suggest that because results were not uploaded in real time to IREV, therefore the election was flawed to a substantial degree, that the results then became not acceptable. And the court rested that matter again. And I think that, I agree completely. I think that was not an issue to begin with for anybody who is familiar with the law and the way the law, is written in this instance.
All right. I will also put Mr. Boka on hold now as we get to cross over to the presidential villa, where State House correspondent is standing by, Femi Akande, to give us just an update from the State House. Femi, talk to us about the mood. The president has already reacted. We've seen pretty much reaction as well from some members of the president's cabinet. But talk to us about the mood at the State House.
Well, Precious, there's intense excitement here in the State House. We have seen visitors thronging into the State House, state governors, ministers. Everyone is coming to congratulate the president and also congratulate themselves as members of the governing All Progressives Congress. This judgment of the Supreme Court is an affirmation of the victory declared by the Independent National Electoral Commission. But, well, they are also taking all of these with all sense of modesty. They are saying, well, it's time to move on. It's time, like we've seen the statement of President Bola Tinubu, that it's time to move on and build the country. It's time for governance. He has stretched out the olive branch to all members of other political parties who went to court to contest the victory that he got at the presidential election. Now he's saying that, well, it's time to begin to build the country. There are so many issues to address in the country, from security to education to healthcare and all of that. And President Bola Tinubu's renewed hope agenda captures all of that and how he intends to ensure that Nigerians feel the impact of his government. Well, I think now the presidency and indeed President Bola Tinubu will be able to concentrate more on governance. Before now, the court cases here and there were a bit of distractions. We have seen so many commentators, people with different opinions, say different things about the victory of the president. But with this affirmation by the Supreme Court, the presidency and indeed the administration of President Bola Ahmed Tinubu will be able to concentrate on governance. Precious.
And as you interact with the visitors, what's the key message, from everyone who has come to visit?
Yes, the key message from all of them is that it's time to unite and line up behind President Bola Tinubu's administration. A lot of them say indeed they know that before now the president won the election. But just as it happens with politics, where people are not satisfied with certain things, they would want to contest in court. So they just waited for the court to decide the fate of that election. But at the end of the day, what they are saying is that, well, first to congratulate President Bola Tinubu, and then also ask people to begin to unite, support the government, support the government of President Bola Tinubu. That it is not a government of APC, but it is a government of all Nigerians, and President Bola Tinubu will ensure that he runs an inclusive administration.
I can see from the pictures, live pictures, from moments ago, not live pictures, I can see that those visitors are also members of the opposition as well. I can see the Bayelsa State governor there amongst the visitors that the president received. Doye Diri, what more can you tell us about that?
Well, for some of the members of the opposition, a lot of them have shown tremendous support to the administration of President Bola Tinubu. For them, as soon as he was declared winner and sworn in as President and Commander-in-Chief of the Armed Forces, the party lines have been blurred. All party differences have been set aside. They now see him as the leader of the country that should be supported to ensure that he delivers good governance for Nigerians, and that is what the visit of the Bayelsa State Governor, who is a member of the People's Democratic Party, represents here today.
Thank you, Femi, for that update. Keep an eye on those visits and the messages for us as well. Thank you, Femi. Let's get back to Felix Mboka. Are you surprised that the Bayelsa State Governor is one of those who visited the president?
Yes, I think that, as I said earlier, the decision of the court today, and in fact, even the announcement by INEC that the president won the election, was sufficient reason for every patriot to rally, because we cannot spend our lifetime disputing the result of an election conducted by the legitimate umpire in our elections, and that is INEC. We cannot. I think that other countries go through this process. The United States, one of the leading democracies in the world, had an election and it was disputed, but he was rested, and President Joe Biden has been governing with gusto. And I don't think there's anybody, even those who with the former President Trump, who think that the president they don't win an election. I don't think anybody is seriously contesting that. But look, I think that I'm glad that Governor Diri and other opposition figures. That's the spirit. That's what we're saying. That's what needs to happen. You can hold on to your political persuasion, hang on to your party, but this is a moment of national reconciliation. It's a moment for patriotism, for everyone to come together to offer a hand with the president so that we can overcome for the sake of our people and in their own best interest.
Thank you so much, Felix Mboka, the National Publicity Secretary of the APC. Nigerians are waiting eagerly the delivery of the renewed hope agenda from this administration. Thank you so much for talking to us.
Thank you so much for having me. Appreciate it.
And to senior political correspondent, Ewa Ozukbako, thank you so much for sharing your years of experience and insights on covering politics with us today.
It's a pleasure, I was.
All right, so that's where we'll leave it now. That's the news this hour. I'll be handing over to my colleague, Tolulokbe Ogunjobi, for Business Nigeria. Thanks for watching.
I wish to welcome you all to the Global Technology Africa Summit.
Technology itself is a massive driver of access to services that, frankly, most of the governments in Africa can't build infrastructure fast enough to meet.
We have to be a lot more conscious of data storage, data ownership, and things like that.
Talent is the human component of technology.
Basically, the Startup Act is a framework and an umbrella. And I think each state needs to look at what exists, how do we capitalize on what the Startup Act is, and where are our own gaps.
The platform for consumption of entertainment content is translating from linear TV or traditional TV as we know it to the screens of those mobile devices.
We're working with NITA to bring them to the U.S. to talk about how we work together on this new challenge of AI.
We have to create a new community.
And we look forward to having you in GTA come November. Thank you very much.
A deadly syndicate. An overdue vengeance. A sacrifice of blood. A coveted crown.
The following is a paid presentation by ShopX TV. Do you struggle with having an active and healthy lifestyle due to your busy schedule? Do you find it difficult to make it to the gym? You want to improve your overall health, but don't know where and how to start? Medical experts agree that walking, running, and jogging are amongst the best ways to stay fit and enjoy a great active and healthy lifestyle. What if there was a convenient and affordable way to improve your health, improve your mood, and lose weight right in your own home? Introducing the SportX Digital Compact Treadmill, the compact foldable treadmill that makes being active and losing weight fast and easy. Just unfold it and walk, jog, or run while you watch your favorite programs on TV. And when you're done, just fold it and store it away. Now that's convenience. The secret is its advanced design that houses a 1-horsepower motor that is twice the size of most treadmills, packed into a nice compact unit, powering every step you take. You get the SportX Digital Compact Treadmill System complete with a rugged commercial-grade ultra-durable traction belt, large LCD multifunctional display that displays speed, time, distance, calories, and has 12 different exercise programs, as well as a magnetic safety key for added security.
The SportX treadmill has really helped me get back in shape after childbirth. I love it because it's compact and can fit anywhere in the house. And when I'm done, I fold and put it away. Easy peasy.
This is the best piece of equipment for people like me who want to stay active without leaving the home. I simply unfold it and use it while I watch my favorite program on TV.
Joining the gym can cost an absolute fortune, and you could be paying up to 600,000 naira in annual gym fees. Get the SportX treadmill to save the cost and work out from the convenience of your home. You could pay 500,000 naira for a treadmill like this, but you can get the SportX treadmill for not 400,000 naira, not even 300,000 naira. Order right now and get this for just 294,500 naira only. But wait, there's more. If you order now, you get the SportX Digital Compact Treadmill delivered to you for free, wherever you are in Nigeria. The SportX Compact Digital Treadmill comes with ShopX 30-day money-back guarantee. If you're not satisfied with the treadmill, send it back for a full refund. But hurry, limited stock available. So, call the number on your screen now or visit our website to place your order while stock lasts. The proceeding was a paid presentation brought to you by ShopX TV.
At TVC News, wherever the big news story is happening, we're geared up to break it. TVC News, first with breaking it.
Is my fatherland. God bless Akwa.
We will invite all Akwa Ibomites to arise to the faith of greatness with our Rise agenda.
The sun is rising, the land is peaceful. It's so amazing that I can see. I want you to
The Shared Prosperity Weekly TV series on TVC News. It is through this telecast the viewers get to know what is happening in the prosperity government of His Excellency Senator Hope Uzodinma, the Executive Governor of Imo State. Through this program, all questions agitating the minds of citizens and residents of Imo State are answered in details with documentary evidence. Don't miss it. Keep a date with us every Sunday on TVC News by 9 p.m.
Hello there. Thank you for joining us. It's Thursday edition of Business Nigeria. Welcome and thank you for being a part of this. Finally, election court cases are over. According to President Bola Ahmed Tinubu, it is now time to focus on good governance. Good governance, yes, business growth and development, according to the president, is the way to go. Take a listen to the president's reaction immediately after the judgment.
I've started from day one to work hard, regardless of, the court cases, okay? And just strengthen my resolve to do more. A challenge of this nature and a future of this nature is more work, and more hard work, more dedication. Just appeal to the sense of patriotism of Nigeria to have a change of mindset. Let us be positive about our country, be ready to contribute in all ways possible. There's no promise of El Dorado from day one. We're all in this boat of diversity, a member of the same family, living in the same house, but stay in different rooms. And it is important that we recognize that we have no other country but this one. So we better be committed to it, not for the sake of our own self-aggrandizement. Our commitment to the values, the creed of dedication, patriotism, and commitment to the value of this country.
President of the Federal Republic of Nigeria, President Bola Ahmed Tinubu there. Well, these are some top stories making headlines across the world of business. Nigeria wants African countries to reposition local content in the oil and gas industry, as FG says Nigeria is a safe haven for foreign investors. Asian stocks slumped to 11-month lows as higher for longer rates fears persist. On our interview segment today, we'll look at the quick wins, recommendations of Nigeria's Presidential Tax Committee. President Bola Tinubu on Tuesday in Abuja received the report on fiscal policy and tax reforms from the committee tasked with improving the nation's revenue profile and business environment. We'll look at that report and understand what is therein. And on the flip side of the show, we shift our focus to understanding the concepts and prospects of a circular economy. It's a model of production and consumption which involves sharing, leasing, reusing, repairing, refurbishing, and recycling existing materials and products as long as possible so that the life cycle of products can be extended. But some news making headlines before we get talking. The federal government says it is a time for African countries to reposition local content in the oil and gas industry to maximize the value chain, boost the sector, and develop the continent. Minister of State for Petroleum Resources Oil, Mr. Atiku Lokobiri, made the call at the third edition of the African Local Content Roundtable in Abuja with the theme Enhancing Local Content Development and Deployment in Africa, Oil and Gas Industry. The aim is to review the approaches and regulations employed to drive local content along the industry value chain and address emerging challenges. The minister says that the event will help build database of available skills as means of leveraging African Continental Free Trade Area Protocol to ease mobility of labor among member countries, thereby reducing dependence on Western nations for manpower expertise. Still staying in Abuja, the Minister of Budget and Economic Planning, Mr. Atiku says the country, despite being faced with some challenges, the president is currently working on making the country an investment haven for investors. The minister said this at the end of the 2023 Nigerian Economic Summit. He said in spite of the country's challenges, the government remained resilient and is taking traveling economic activities to all parts of the country. On his part, the chairman of the Nigerian Economic Summit Group, Mr. Olaniyi Yusuf, challenged the private sector players to come up with ideas, recommendations, and solutions that will help the government in addressing some of the economic issues in the country. Some company news. Transcorp Hotel PLC, hospitality subsidiary of Transcorp Group, has announced its financial performance for the third quarter of 2023 with a strong year-on-year growth in all indices. The leading hospitality company in its Q3 2023 financial performance report shows that the hotel sustained increased momentum of 62% profit growth. The report shows a recording 31.76% growth in revenue to 29.9 billion naira from 22.7 billion naira the previous year, higher than the pre-COVID performance with profit growth of 62% to 5.5 billion naira from 3.4 billion naira. Managing Director CEO of Transcorp Hotel PLC, Ms. Dupe Olushola, said the growth recorded indicates the company's dedication to excellence and resilience in the face of economic challenges. She assures that the company will continue to experience strong performance in its international business travel segment, as it is committed to delivering exceptional value to its stakeholders and sustain its growth momentum. President Bola Tinubu has received the quick win report on fiscal reforms and fiscal policy and tax reforms from the committee tasked with improving the nation's revenue profile and business environment, chaired by Mr. Taiwo Oyedele. Reacting to the presentation by the Presidential Committee, President Tinubu commended the work done by the committee and assured them of his support for the review and implementation of key recommendations. The President directed immediate implementation of the committee's recommendations with immediate effect. Well, joining us on the program live is no other person but the chairman of that committee, Presidential Committee on Fiscal Policy and Tax Reforms, Mr. Taiwo Oyedele. Thank you so much, Mr. Oyedele. It's really good to have you join us this afternoon. Good afternoon to you.
Good afternoon, Tolu. Thank you for having me.
Yes, I see a lot of pointers in that document. We can go on and on. About 20 of them you even put on your page and all of that. But can you do an overview before we now get into some specifics? I see some that are really definitely going to impact everyone. But give us an overview of this report, then we will now get to some segments of it.
Yeah, thank you very much, Tolu. Like you rightly mentioned, we presented the report to Mr. President. And the details of that report, some of it we have shared publicly. Those 20 points that we summarize are just a, maybe small component of the report itself. It's a lot more that is in it. But we thought that it would be appropriate to allow the President, and of course, as you may be aware, we have requested for a session with the Federal Executive Council, which Mr. President has obliged. In fact, even offered whether we needed a special session of FEC, just to give you an idea of how much priority the President is according the work, which we are very delighted to know about. But broadly, this is the phase one in terms of the deliverables of our committee set up by the President. We have the quick wins. That's what we're working on now. The second phase is critical reforms, and phase three is implementation. And all these three phases run concurrently. Broadly speaking, the mandates of the committee are divided into three pillars. One is revenue transformation, which is essentially how do you mobilize revenue to fund government and borrow less. The way we have been doing in the past few years is not sustainable to keep borrowing, particularly from the central bank via ways and means, which is fueling inflation and taking more people into poverty. But also that pillar of revenue transformation also focuses as well on non-tax revenue, both oil and non-oil, other solid minerals, including government-owned enterprises and government assets. The second pillar of our work is to do with fiscal governance. Essentially, how can we get better in terms of how we spend our money? How can we get better coordination between policies of government, particularly monetary and fiscal policies? How can we get better coordination among agencies, but also in terms of vertically with, sub-national government. We have been having engagements with the National Economic Council, where you have the governors. We have had a session with the Senate, actually a whole retreat just to discuss the work of our committee. So the third pillar of our work is growth facilitation. When we talk about economic growth as the most sustainable way of, raising revenue and also providing prosperity for the people. So the report we submitted to Mr. President, like I said earlier on, is a quick wins report, which is the phase one of our assignment. And broadly speaking, we try to address the issues that are most pressing to our country at this time. Of course, I think number one on that list that most people will agree to is the exchange rate management. How can we get stability in the exchange rate of the Naira, particularly to US dollars? How can we close the gap or eliminate the gap between the parallel market and the official market? Because that is holding back inflow of foreign direct investment, diaspora remittances, and foreign portfolio investment. And of course, the other very important and pressing issue is to do with the subsidy removal, because the after effects of removing the subsidy has meant that there's a lot of sacrifice by Nigerians, but even more so Nigerians who are low-income earners and are just barely getting by. So life has been very difficult. So the whole idea in terms of our recommendation is, what can we do in the immediate term to relieve people of these, pains? And how can we also, more importantly, start bringing the benefits of the sacrifices that Nigerians have made into life, so they can begin to see the impact and actually truly believe that those sacrifices were worthwhile. And then we also have other interventions around, facilitating the ability of Nigerians, particularly young people who are tech savvy, to be able to find jobs within the international global value chain without leaving Nigeria. So this is conceptually about how can Nigerians who want to remain in Nigeria find jobs within the international value chain and earn dollars while they're here, which is not bad, to be honest. Apart from those people being able to earn very decent income, lift out their family members from poverty, government would also not only earn inflow of foreign currency to manage Naira better, but also the state governments will earn personal income tax from those individuals. So it seems like a fantastic idea we should have done like 10 years ago, but we're trying to do it now. So the recommendations we have made, we have also put them under different categories of how would they be implemented. Would we need an executive order to be signed by the president? Do we need an order to be signed by the finance minister? Do we need a circular by the FRS? Do we need the central bank? Central bank is autonomous, so nobody is directing them or dictating anything to them, but we're working together, and therefore we have some recommendations that would be necessary for them to consider and make decisions over those. Particularly, if you think about the 43 items that were previously prohibited from accessing foreign exchange in the official market, and the central bank lifted that ban, and that meant that from the fiscal side, we needed to quickly respond so that we can protect local firms that are producing those items and so on and so forth. So in a nutshell, it's quite elaborate in terms of the work we have done, and I would like to also commend members of our committee as well as the Nigerian people, because we have received an enormous amount of support from everyone, organized private sector, even the media as well as institutions of government and the international community.
I must thank you so much. Now, using technology data for tax to expand tax net is one thing I'd like you to touch on. You also talked about tax break for private sector as a result of wage increase for low-income earners, transport subsidy, and also net increase in employment. These are really human angle decisions that would affect every Nigerian. Facilitating the use of mobile phones also for the conditional cash transfer. Tell us more what you expect impact of all of this across the economy?
Yeah, so if I start with the one about facilitating mobile phone to transfer, money to poorest people, we know that there's trust deficits, especially between government and the Nigerian people, and a lot of that is based on history because government has not behaved the way we expected for a long time. We haven't seen discipline around financial management. We haven't seen prudence. Sometimes accountability was lacking. So to be able to do that, you cannot decree or enact, trust into existence. You have to earn it. And part of being able to earn it is change your ways and do things more transparently. So one of our recommendations is conditional cash transfer to the poorest people. Why can't we use mobile phone to do that? Even if they don't have bank accounts. So most of the people you are targeting, they have one phone or the other, even if it's not a smartphone. So you can then transfer, monies into their, phones as wallets or food stamp, and they can use that in exchange for the food they want. For example, why are we buying rice and sharing it? Maybe somebody wants yam, maybe another person wants gari. So when you give them the money, they can make those decisions for themselves. We're also working on what we call a spending framework that we are recommending to all levels of government as to how they should spend the windfall from subsidy removal and foreign exchange harmonization. And we are planning to, to create a portal where you can go there and see, all the 36 states in Nigeria, the federal government, and the FCT. And if you select Lagos, for example, it will then also give you the option of all the local governments. Let's say you select Etiosa, and it will now tell you, all the projects that are ongoing, the location of those projects with videos about progress and photos, that the civil society, we are partnering, we intend to partner with budget, but we're also even inviting the Nigerian people to also help us with that monitoring. Now, that will help us build trust, ensure more transparency, and therefore people will begin to accept that government is really working for them. So on Data for Tax is an initiative that has been ongoing for over 2 years, and is the whole idea of bringing the intelligence within the economy together so that you know what everybody is doing. So whether you have activities through your payment cards, your bank account, your investment account, stockbroking account, travels abroad, importation, and so on and so forth. This intelligence is collected, and therefore, one, we can use that to determine the poorest people that need to be protected from tax burden, or even need to receive some, conditional transfer for their livelihoods. And then we also recognize from there those who are middle class, upper class, high net worth that need to pay the right amount of taxes. So that's the concept of the data for tax. And we think that this is critical not only for revenue generation, but also for economic management, particularly from the social aspect of things. So these are some of and then the recommendations around the amount to be exempted from personal income tax to be increased. Currently, as we speak, 30,000 naira or below is exempted from personal income tax per month. But with inflation and cost of living that is rising, realistically, no honest person can live well, maybe not even live well, can hardly survive on 30,000 naira per month, even if they were living alone. So what we are now saying is, it's time for us to review that amount. Maybe it should be 70,000, maybe it should be 80,000, maybe 100,000. We're going to use data to do the analysis and recommend, and you would imagine that this is not just for the federal government, the state government in particular need to decide on this. So we then enact it into law and just increase the threshold for which there will be no personal income tax, because those people are considered to be really poor. And then we also thought that whenever we're doing interventions, we tend to do public sector. We know that federal civil servants were awarded 35,000 naira per month wage award for the next 6 months or thereabouts. There wasn't so much for the private sector. So our recommendation is we need to give something to the private sector because they're also Nigerians and they're making sacrifices. And we are trying to do that by way of employers that give additional salaries to their low-income earning workers. or they provide them with transportation or transport subsidy, or employers who are doing their best to hire even more people than they have done, averagely in the past 3 years, are to be rewarded by way of an additional deduction against their corporate income tax, which is a form of incentive. So these are some of the way to respond to the question you asked.
Brilliant stuff. Let's wrap up with implementation. Implementation is key. I'm wondering, is there any way we're going to evaluate and monitor so that we start to, see the positives of this at the end of the day?
Yes, indeed. So the president was very clear to us that he's not just interested in a committee writing reports. He really wanted us to be able to help with implementation of approved proposals and interventions, which is also the reason why many of us are very excited about the work. This very popular knowledge and notion in Nigeria that Nigerians are like the smartest people around. They have good reports, but nobody implements those reports. So we want to do it differently this time around. As something, if we make a proposal today, it's approved tomorrow, we start implementing the day after tomorrow. So after discussing with Mr. President, some of those recommendations, we're already working on the implementation. And people will begin to see the outcome of those implementation in the next few days. And that will run all the way, into weeks and months. Some of them will require that we go to the National Assembly to enact a law. So we are working on a bill that we call Emergency Economic Intervention Bill. So that bill would enable us to address changes that we want to do, urgently, but cannot be done by the president, can only be done by the lawmakers by way of amendment to existing laws. For example, we want to allow Nigerian companies to be able to pay their taxes in Naira, as opposed to currently where, we have a provision in the law that says if you pay any transaction in foreign currency, the applicable taxes must also be paid in foreign currency. So this is putting a lot of pressure on businesses and a lot of pressure on the Naira and the foreign exchange market, as well as the ability to deal with legal and tax impediments that are coming in the way of Nigerians in Nigeria finding jobs within the international value chain. So this once we go to the National Assembly, we have met with them. They are very willing to help. We're hoping that will not take too long. In a matter of weeks, thereabouts, we should be able to get the outcome that will begin to make the impact in the lives of Nigerians.
I must thank you so much. Interesting chat with you as usual, Chairman, Presidential Committee on Fiscal Policy and Tax Reforms, Mr. Taiwo Oyedele. Do enjoy the rest of your day.
Thank you, Todo.
Well, a lot there being done around the fiscal space. Well, coming up next on the show, we'll shift our focus to break down this concept called secular economy and its prospects, and a partner at PricewaterhouseCoopers, PwC, Mr. Siri Agbeyi, will be joining me after this break to continue this conversation. Don't go away. It's Your Business Nigeria.
Information and entertainment like never before as TVC Breakfast takes your weekends to a whole new level. Introducing TVC Breakfast Weekend Edition, your ultimate source of thrilling sports updates, insightful political analysis, and captivating entertainment news. Stay in the know with what's trending, catch up with the latest in sports, and immerse yourself in the latest buzz from the world of music and movies. Your weekends are no longer just days off, but moments packed with knowledge, excitement, and enjoyment. TVC Breakfast Weekend Edition, only on TVC News.
Business lives on the fast track of numbers. Business is a strange world where low numbers means something different. And its currency are speed and time. Finding the open doors of Main Street is not just good business, it's the start of the business. Join us every weekend on Business Week.
Information is power, information is security, information is knowledge. On Labor Lens, we believe that working people around the world have real questions of their own. They want to know how the world of work operates, what it means to the employer of labor, how policies affect workers in the workplace. On Labor Lens, I ensure we engage effectively the organized labor, organized private sector, and government to get out of them information workers are in need of. I am Sharon Ijason, asking questions that make you get sense of the workplace.
The TVC News at 7 and the TVC News at 10 are not like any other news broadcast.
It's the big news hour, the hour for the big breaking stories.
We've got some of the best reporters on the field,
taking you through as it happens.
It's fast-paced, hard-hitting,
with investigations that matter.
bringing in news that affects your life.
With sport, entertainment and business news so you don't miss a thing.
Experience resourceful coverage with depth.
Every night.
Doubt and fear doesn't occur at the canvas, it shows in the canvas. It shows the conation of raw earthen material slabbed, stroked and molded at a pace provided by the doubt and fear. Every move way in the struggle of one to the other, merging the past to the present, brushstrokes of colors seen but not known. For when the wailing stops, the pieces settle down in abject beauty erected for a century of a century. Speaking, advocating, protesting as the arts are meant to be.
Glad to have you back. The United Nations Conference on Trade and Development defines the circular economy as an economic model focusing on closing material loops through repairs, reuse, recycling, refurbishment, and remanufacturing of end-of-life products. Estimates suggest that only 8.6% of the world's economy is circular. Over the year, the circular economy has gained prominence in Nigeria, given its potential to offer helpful solutions to pressing environmental and economic challenges. Well, I have with me a partner with PricewaterhouseCoopers, Mrs. Siri Agbeyi, a partner FCA. She helps entrepreneurs build sustainable businesses and solve their problems through finance, tax, family governance, environmental, social, and corporate governance. She joins us via Zoom. It's good to see you. Thank you for your time.
Thank you so much, Tolu. It's always great to be on your show. Thank you.
Yeah, I appreciate that. Tell us more about circular economy, and are we really taking advantage of that in this part of the world? Are we keying into it? Are we taking advantage of the positives in this space at this time?
Yeah, I think you rightly introduced the subject. And maybe just to also add to that, it's really about ensuring that we are growing for the benefit of current generation and future generation. And it requires a lot of change in the way we have done business. Prior to now, we've done businesses in such a way that, unfortunately, we have harmed, the planet. And one of the very clear examples is perhaps the cost of carbon emissions, which has continued to deteriorate the planet as we speak. What the circular economy is looking to do is to say, can we change those business models so that whilst making profit, we're also protecting the planet? The other thing as well that's coming through from circular economy model is we have seen a lot of increase in inequality. So there's a huge gap between the rich and the poor. And this is why the United Nations came up with something we call the Sustainable Development Goals that really looks at it from a 17-point agenda to say, what are those critical areas that we need to address now if we must save posterity? So all of this is, can we change the way we've done things normally? Is there a better alternative? What's in it for us? And the ultimate answer to that is there is a huge economy awaiting us to exploit and explore, and that even runs into millions and trillions of dollars. But are we really tapping into that economy as we speak, at least in Africa? Not in its entirety. There are things we could do differently and better, which is one of the reasons I talk about this topic.
Regulations and policy always key, just like in the digital economy, same for the circular economy. So I'm worried, how well are we getting it right with regards to regulation and policies that could help us achieve all that you laid out?
Yeah, I think at least if I use Nigeria as an example, we probably still have miles to go. Last year, we did enact the Climate Change Act, which is supposed to help drive some carbon taxation that would ultimately reduce the emission of carbon. Nigeria has also been signatory to the Paris Agreement, which looks at us reaching at least net zero by 2060. This is the deadline we have given ourselves. Unfortunately, there is a lot of misunderstanding out there around what we're required to do, some of which is we totally need to stop exploiting our oil and gas resources because we want to look at cleaner energy. But I mean, the ultimate is that we need to start looking at a transition that is just and balanced for society. And the way we have issued regulations may not necessarily be aligned with the ultimate goal. Now, when I look specifically at some of the examples on circular economy that we could do differently, just say plastics, for instance, or even packaging, because we have about over 40% of our packaging in plastics attributed to the manufacturing industry, which we could change, because when you look at the effect of using those plastics as packages, there's a lot around the drainages that we clog, the floods that increase. The floods then affect our produce on land. And whether we like it or not, if produce is affected, livestock is affected, there's no way we can sustainably secure feeding for our people. So it's important that we put the right regulations to yield the right results. Right now, we have over 34 legislation and policies in this space as it relates to how we dispose of packaging, and most of them are targeted at waste management. What the circular economy is looking at is to say, can we look at it from the top? How can we design effectively so that we don't have as much waste? How can we produce effectively so that we don't have all of these tomatoes, for instance, that we harvest, that's all being disposed of because we can't store them effectively? So what the circular economy regulations should be looking to do is not only to change and support the change in the business models of our producers, our companies, manufacturers, the top end of the chain, but it should also be looking at seeking to balance the spread of incomes across our people. It should be looking to sustainably generate revenue across the nation, which is where tax is coming. It should be looking to reduce also the incidence of waste, because if we're able to design with, for instance, equimodular criteria, modulation criteria, we might as well be looking at reducing ultimately the waste that clogs some of our seas, drainages, lands, and everywhere. And that reduces the cost that we spend as a nation. We can then redirect those revenues to better use than where we currently use them.
Interesting stuff. Well, looking at this, how much of awareness have we done, or where are we with regards to our awareness? How aware are Nigerians too keen to this? Because we don't hear about this everywhere.
Yeah, and I mean, I love that you asked this question, Tolu. It's one critical area that does need a lot of focus, especially when you consider that most of our GDP sits with the informal economy, and not everyone is vast when it comes to understanding the nitty-gritty of this, but it can be simplified. It can also be elevated to the area of importance that it deserves. Because whether we like it or not, if we continue to do things as we've normally known to do, we run the risk of not saving potentially for posterity. And that's what the circular economy is seeking to do. So in terms of raising awareness, there has to be a top-down approach and also a bottom-up approach. Top-down in the sense that it gets the importance that it deserves and recognition it deserves at the presidential level. Now, I recognize that there is a Climate Change Act, We also recognize that there are policies and laws that have been perhaps initiated by some of the agencies. But in terms of harmonizing what the messaging is behind those regulations are, we are lagging behind. in terms of having the presidential gravitas that the circular economy deserves, we are also lagging behind. Because why? We see that there's a lot of focus on the oil and gas economy, and in recent times, the blue economy. But all of this would rely on the circular economy at best, because what we're saying is you need to integrate sustainability in all areas of the country, in all areas of the economy, and by doing so, we generate an additional layer of economy. In terms of raising the awareness, we all need every hand on deck, all stakeholders, including the companies as well, because when you look at the nitty-gritty, the companies have caused some of this problem, and they actually are the custodians of the innovative solutions that would change it. Now, some companies are doing some bit around raising that awareness and saying, for instance, where can we pick up plastics that we have used? How can we sort them properly? Are there enough collection centers? Honestly, I must confess that even me, I don't know the collection center near my house. So I might sort my plastic for all I want, but in terms of getting it to the right quarters, you might find that some of it may get missing. It may get into the dump site. When it gets to the dump site, how are these also being sorted? How are they taken to perhaps a recycling hub? We don't have enough recycling centers or plants across the nation. Some of them are probably clustered in the south, and they're only so few because it requires a lot of investment to do so. So in terms of raising awareness, there needs to be communication in languages that we all understand. It needs to be simplified to such an extent that you understand how your individual activity can cause a destruction in the planet. And it's not just about plastics alone. There's a whole lot of discussion around all sectors in the environment. We can do things differently, even in terms of farming as well. When I was studying agriculture in the secondary school, we used to talk about nitrogen fixing plants, and some of the ways we have brought in fertilizers now is causing more harm in our soils. And what that effectively means is that what we consume also stands a chance of being altered. So I think we have a long way to go in terms of making sure that the awareness is simplified, it's basic enough, and it would not only be the private sector that does this, it would also be the public sector in the way we draft our policies, in the way we draft our regulations, in the way we also embed this circular economy thinking in everything we do, from tax policies to manufacturing to tech-enabled businesses. Everything has a circular economy message to it. And all it's going to do is really going to quadruple the economy for us. And it's really a resource that's untapped as we speak.
And so you mentioned something very important now, capital investment. It's not cheap, talking about recycling and all of this. So are we looking at incentives here or subsidies here to help achieve this aim in its totality?
Yes, and a lot of countries have done this. This is not the first country that's speaking about circular economy. Some countries that are really advanced when it comes to this, like the EU, they have a Fit for 55 project around ensuring that they reduce also their carbon emissions, and they're even imposing taxes as well on companies that are exporting into their jurisdictions with very high duty carbon elements. For instance, if you're exporting fertilizers or oil and gas into the EU, there is an extra layer of taxation that you have to face because they want to also guarantee a stable, competitive environment for their businesses. Now, in terms of the incentives as well, there are incentives that are being given to companies that advance the circular economy concept. So to the extent that you have eco-friendly products, the products in that sense are a bit subsidized, and